May it please your lordship. My lord, I would like to, my lord, item number 61 and 62 of supplementary list. There is a little correction of your lordship order, my lord. So I pray for either application.
I'll do it. Otherwise, if not possible, we'll list it tomorrow.
Only urgency, my lord, it is fixed, Leonard court will fix
I'll
today.
try to do it, or otherwise tomorrow morning.
Lordship, I have prayer with respect to item number 31, 32, Lordship. My pain is there. I need some more time, Lordship, to get
31, 32.
31, 32, Lord.
Okay. How much time you need?
Lordship, maybe after vacation, Lordship, puja vacation. Sorry, leave vacation.
Okay. Who is present? Yes, Mr. Karma, Learned Counsel Board of Petitioner is present. Mr. N. Upadhyay, Learned Standing Counsel, Irrigation Department, has sought for and is granted
3 weeks time, Lord.
3 weeks time to file, to obtain the necessary instruction and to file a counter review on behalf of the respondent Irrigation Department authorities.
Can a date be fixed?
Release the case on so and so. Same 32.
Oblige, Lord.
2904.
With the consent of the other side, I beg to mention item number 34, your lordships. Lordship-
34.
Yes, your lordship. Lordship, we need 2 weeks time to file our affidavit in reply.
Okay. Who is for the petitioner? Oh, you have taken consent, Miss
S. Sarkar.
S. Sarkar.
Yes.
You are on behalf of whom?
N. Havelia.
Okay. The Learned Counsel for the petitioner has sought for and is granted. How much time?
2 weeks time.
2 weeks time to file affidavit in reply. Full stop. It is submitted that consent has been taken from the Learned Counsel for the respondents to make the prayer. List the case accordingly after 2 weeks and date to be fixed by the office.
Lordships for listing, lordships.
Listing of what?
For admission, lord, service matter, lords.
Service matter or not before this list? Ben Sri.
Lordship, I beg to mention item 8 for adjournment as senior counsel, Mr. P.J. Sekia has some personal difficulties.
Yes. What do you want?
Lordship, can the matter kindly be taken up on Wednesday?
Or not Wednesday, Friday?
Lordship.
On the prayer of Miss
Lordship, M. Bhuya on behalf of senior
M. Via,
counsel, P.J.
Learned
Sekia.
Counsel on behalf of Mr. P.J. Soikel and Senior Counsel for the petitioner lays the case on so and so. It is submitted that consent has been taken from the Learned Counsel for the respondents to make the prayer.
May please your lordship. I pray for listing of an admission matter, my lord. It was left over on 19, my lord. Contractual bill, my lord. And
After vacation.
similar matter is fixed on 25, my lord. On the same contract, my lord. So may I pray on 25, my lord? Because it is supposed to be disposed of on 19. Your lordship has taken up the matter.
Let it don't prolong the list. Let it be after.
25, my lord. If possible. my lord.
Contractual basis is not urgency.
Please, your lordship, I beg to mention item
Court
number
master gives the date.
Item 23, your lordship, we have filed an additional affidavit to bring on record some documents, lordship.
Item 23.
Yes, your lordship.
Okay.
Lordship, may kindly allow us to bring it on record. Highly obliged.
May it please your lordship. I beg to mention item number 18, lordship. Fixed matter, lordship. Affidavit was filed, lordship. A lead petition was mentioned. May it come up on 30, lordship.
You are for the petitioner.
Petitioner, lordship.
Item
18, lordship.
18 is tagged with 19. Okay, you have in front of the other side. Let it be called then at the time.
Daily list promotion, item number 1.
Yes, instruction.
My lord,
No instruction.
instruction, some verbal instruction is there, lordship. Regarding amount, my lord, some verification is required. But lordship, the Department of Agriculture 11,72,000 has been released. Now, since the budget finance year is approaching, 52 lakhs out of the said amount has been reward back.
My lordship, similar person, my lord, same then the payment has already been made, my lord. So authority shall verify it, my lord, whatever.
No, without, no, we can do it,
Yes, my lord.
but without admission of liability, how can we say that?
He has said, my lord, amount is admitted.
Some verification is required, lordship.
Verification, my lord, what amount due, my lord, that may be paid, my lord. And one order I have annexed in the petition also. That is 1 crore something, and that is 76 lakhs, my lord. We are, my lord, small amount, my lord. And they have stated that money has come for the budget.
Yes, Lordship, but out of 11 lakhs, 11 crore 70.
So there is nothing on before the court. He is making some submission orally.
Verify it, my lord, what amount due?
Oh, this verified has come under severe criticism.
My lord.
Please consider verify jurisprudence. Shall I show it? That this consider jurisprudence, verify jurisprudence is very bad.
But thing is that, my lord, 1 crore and 76.
Why don't you file your affidavit?
Lordship,
Let them file, my lord, on 30, some matter has been fixed, my lord. Let all the matter has been.
What is the difficulty?
Lordship, we will file it, Lordship. Just 2 weeks time may be granted, Lordship. We will
Lordship,
file.
before take, my lord, only thing whether this amount is, my lord.
Lordship,
No. This court is not
Your lordship is correct.
interested.
Yes, your
Not
lordship. is correct.
interested, Mr. Chaudhuri.
Yes, madam.
I am making it very clear.
Your lordship is correct.
Unless we get the affidavit.
Yes, madam. Only thing is that, my lord, that big amount has already been released, my lord. All big amount, my lord. We are small type contractor, my lord.
Right.
Yes, madam.
But there has to be definite direction. This verify, examine.
On that, my lord. And the date them he filed.
let them
38
come.
March. And
But
all.
Mr. Zaman don't take adjournment again.
Lordship.
Yes, madam.
Lordship, 2 weeks time may be granted. Within 2 weeks, we will file our.
Because, my lord, they want to 31st March because this payment has been mailed to all the big contractor, my lord. That is my humble submission before your lordship, madam.
Unless we get some response from the respondent.
Yes, madam.
All the respondents are represented?
Yes, sir. Some money is available. Sir.
Huh?
No money is available, Lordship. Some money we have received out of those money, as because the Lordship financial year is approaching, we have reward back, Lordship.
Lordship, kindly last part of the order, my lord. I won 1.72 lakhs has been allocated to the agriculture for budget finance 2025-26. Para 3 of the order, my lord. That is, I am asking for 38 March, my lord. And Mr. So-and-so understanding of the express finance department informed that bill of the can be from the said amount 1172 lakhs, my lord, for the financial year allocated to 25-26.
Where is the submission of Assam Seeds Corporation?
Assam Seed Corporation submission is not available, my lord.
That is not available.
You know, they are appearing, my lord. I am coming, my lord.
There is no
Yes.
submission.
Understanding Council, Assam Seed Corporation for the respondent number 4.
Where is the admission? They are paying. Where is the submission?
They agree, actually, my lord, who
Where is the admission by them? Some budget, something.
Yes, my lord. I'm coming, my lord. G. Bora, so-and-so. Recording the submission of para 5, my lord, of my petition, my lord. Yes, 48. This is
No, in the order. You are relying upon this order.
Another order annexed in the petition, my lord. Your lordship, kindly come to the page 46, my lord, is the order, and para 5, page 48, my lord.
Where is the submission?
Page 48, my lord.
Seed Corp. I have seen. Page
Yes, my lord.
Standing Council, Agriculture Department, Finance Department. They are not the disbursing authority, mister.
Yes, ma'am. Standing also for the due.
Where is that?
I leave it to the lordship. If it is possible, 38 must be possible, man.
Lordship,
It is not possible for the
38 must, because
You have approached. What did you do? You approached in March, right?
no, my lord. I am filing long back, my lord. Too.
January.
This matter, other matter has been filed long back, my lord. All the matter.
Okay, all the cases will be disposed of, but without fail, you file your sum.
Lordship.
Heard Mr. N.L.D. Chaudhary. Learned Counsel for the petition. Z. Bora Learned Agriculture Department, Understanding Counsel Agriculture Department. For the respondent number 1367. Mr. B.B. Jaman,
MM Zaman, Lord.
M.M. Jaman. Who is for finance? Miss R.M. Bolwa. learned counsel on behalf of Mr. H. Alia, learned standing counsel, Finance Department for the respondent number 2, and Mr. M. Jaman,
4 and 5, Lordship.
the respondent number on behalf of Mr. S.
Somoria.
Somoria, learned standing counsel, Assam Seeds Corporation Limited, for the respondent number 4 and 5. Side of CLE banai dibo. All are represented?
Yes, sir.
8 and 9? What about 8 and 9?
8 and 9, 5 and 6, my lord.
What about 8 and 9?
I don't.
You don't have a repetition,
My lord, one.
perhaps.
I am for the 8 and 9 also, my lord.
Claiming an amount of rupees 3,90,911. Sorry, 4,50,334. Seeking a direction to the respondent authorities, more particularly, Assam Seeds Corporation Limited authorities, to release an amount of rupees 4,50,334. The instant repetition is required. Issue notice returnable on 22nd April. 22nd April. As so and so appear accepted. No problem with this extra copies. The respondents shall ensure that its affidavit its counter affidavits are filed on or before the returnable date, traversing the claim of the petitioner for rupees, traversing the claim of rupees so and so made by the petitioner. On sub, it is an endeavor will be made for disposal of the petition on the returnable date. More particularly, Assam Seeds Corporation. More particularly, respondent Assam Seeds Corporation authorities. You file it.
Lordship, I'll file.
Don't avoid it.
I'll file, Lordship.
Do it the same.
Amount.
Amount coming money.
Of the job. 15,21,679.
Yes, my lord.
5 and 6.
And 5, 6 also same.
So 5, 6, let us see. $7,08,896. Respondents are serially same.
Same, my lord. And this is my lord. Amount of.
4,06,887.28.
Yes, my lord. One assurance he has given, my lord. In other subsequent budget, he will my lord, asking money in subsequent budget. He said, my lord, he put.
Lordship.
That may be recorded, my lord.
Huh?
That may be recorded, my lord. He said-
What?
In subsequent.
Mr.
budget, he will
Somoria.
make-
Mr. Somoria,
My lord.
no instruction.
My lord, the instruction we have received, or instruction we have received, thing is that, my lord, there is no any doubt about their liability, my lord. Now, fund which we have already, by the directive of that has already been remanded back to the government. Now,
Whatever, why don't you place a short
my lord,
affidavit
that's
on the
why,
next date without
my lord,
fail?
affidavit is because this new situation that has developed, this lordship is sometime will definitely file affidavit, man.
We are giving you 1 month time,
Yes, my lord, absolutely, man.
but
That-
without fail.
Yes, yes, absolutely. I am taking my responsibility, man.
He has said, my lord. In subsequent budget, he made proposal that.
He is standing counsel, his statement without,
Yes.
let it be
But
filed.
without, my lord, suppose a order will be passed, suppose a fund is not available, serve no good purpose.
Let it be filed.
That's why.
Applies.
A similar matter is also there, my lord. Same cause of action,
Which one?
33 and 40, my lord.
Same.
Same, my lord, but in notice long back it was issued, my lord.
No affidavit.
No.
My lord, definitely we will file it.
Mr. Somori is reluctant to file affidavit.
No, my
My lord,
lord.
small amount.
Which one?
33 and 40, my lord.
33 then one time goes up.
33?
And another is 41.
Okay. Number লিখি দিব Mr. Somorial and standing as Assam, sorry, Lyok. The respondents were put to notice as far back as on 7, were put to notice on 7/11/2025, specifically directing to bring on record their stand by filing the affidavit on or before 22/01/2026. First of yet, comma, no, the affidavit has been filed till date. First of, a last opportunity is granted to the respondent authorities to file the affidavit on or before 22/04/2026.
We'll file, my lord.
It is observed that in the event no affidavit is filed, comma, that repetition will be considered on the basis of the materials on record.
My lord. Deeply.
Same. More particularly, the Assam respondent Assam Seeds Corporation Limited. To notice on 1912, sorry, not 1912, on 1912, 2020. I can say. Same date.
Right.
All on
42 40 my lord.
33 and
41.
40.
Yes, sir.
Right. Let them file affidavits. Heard Ms. D. Chaudhary, learned counsel for the petitioner. Ms. D. Bora, learned standing counsel, Health and Family Welfare Department for the respondent number 125. Ms. I. Morua, learned standing counsel, learned counsel on behalf of Mr. P. Nayak, learned standing counsel, Finance Department for the respondent number 6, and Ms. A. Bora, learned standing counsel, Common National Health Mission for the respondent number 7 and 8. First of Ms. Bora has submitted that. Submitted an instruction, comma, the amount claimed by the petitioner has been withheld in accordance with clause 18 of the REIT contract agreement, which provides for, which has provided that 90% of the payment is to be released upon delivery of items, and the remaining 10% upon satisfactory installation. First up, as there is no installation reports, the balance amount of rupees 12,99,500 has been retained as part of contractual provisions. First up, Ms. Bora has sought 3 weeks' time to bring the stand of the respondent NHM authorities on record by way of affidavit issue notice. The notice is made returnable on so and so after view. As so and so if you had accepted no formal notice, extra copies within 2 working days from today.
2904.
Your Lordship, may I get a copy of that instruction for my client?
She'll bring it on affidavit. You can have a look. You can have a look.
Yes, I put it. Obliged.
Item 4.
Just a minute.
নতুন ডিভাইস হবে নতুন কি রিপোর্ট আছে নতুন রিপোর্ট আসলে তো কানেকশন প্রবলেম হচ্ছে এটা তো এটা ভুল ঠিক আছে আমরা ফেস করব কানেকশন না 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 যেটা নতুন রিপোর্ট না আবার হলো না এই ফোন সমস্যা হয় কি কথা রিপোর্ট তো আছে বলে কেস আগে চলে গেছে কানেকশন প্রবলেম আছে
Yes, what about the existing electric connection?
I'll just provide. Right, because this was the connection, which was taken long back in the name of my father. What we can gather, for Lordship will see the first, this was the receipt of 2000, the consumer number will be there, I have marked it. Lastly, 295, this is of connection of 2015. Now,
Subhas Devnath, who is he?
he was my father,
Father.
Yes, the Lordship will see next page. On the last occasion, they had supplied a instruction. The consumer number is the same. This is our bill dated 12th of November 21, The load capacity is 12 kilowatt.
Bill date is also 8 March 2026.
That is the last one. It is in respect of that connection. There are two plots of land. We are residing somewhere. This is in respect of my residential connection. This has nothing to do with the present connection, which where I am seeking. And this is a completely permanent, temporary connection.
Which one?
The present one which I am seeking, in the particular plot of land. That is a completely different land from that where I am residing.
What is it? What is temporary connection? Temporary connection, I understand in a case of marriage function.
Yes, my lord. In fact,
or something like that.
No, he's trying to, probably some boring activities and those things, my lord.
Because I understand either for marriage or some function, some meeting,
Exactly.
temporary
Now,
connection.
Lordship will see.
This is temporary connection. You are seeking in
Yes,
this.
yes, temporary connection, my lord. And in fact, my lord, this can taken, if your lordship sees the impugn order, which I pay 60.
Now, Mr. What is your instruction?
My lord, I have received some instructions, but
They are
they
placing
have
one.
also informed me that they will receive the trace maps of both the ducks today, today, my lord. So, my lord, the instructions are not very.
What kind of DAG number? The other DAG number?
My lord, but page 6, lordship will kindly come to page 66. They go to a different plot of land, my lord. They say they find the connection there.
No, you are saying now.
Yes, my lord.
You are seeking connection to DAG number 690, right?
Yes.
Now you are saying the other connection
Is in, my lord, that is a different plot of land which your lordship will find at the bunch of documents last page, my lord.
bunch of document you have placed today.
The last page, my lord. It was in the name of Subhas Devnath, the land, my lord. The connection is here. That number is 814.
814.
is the earlier, that is a different connection altogether. my lord. Nothing to do with the present connection. my lord. They say that.
1 minute.
Lordship.
Where is the court order? Where is the other court order? The court order? 1241. 1 minute.
There is a decree in my favor at page 25, probably. my lord.
What is 3858 2025?
You got 3858, my lord. But that they have withdrawn, my lord, it's the order. my lord.
That is a lordship will find it annexure 2. Ultimately, it was withdrawn.
Huh?
Ultimately, it was withdrawn. The initial order was at page, my lord, 44 of the writ petition, and subsequently, my lord, it was withdrawn. And in fact, my lord, we were asked to approach the civil court, and civil court has filed, there is an injunction order to that effect.
What is contempt case?
My lord, in a contempt case, my lord.
What had happened, my lord? There was,
At whose instance the contempt case?
my lord, both the, my lord, not the, my lord,
against
ACB,
APDCL,
not related to the
not
ACB,
against
the
APDCL.
police authorities, my lord.
This, my lord, Pradut, my lord, the other guy, my lord, who applied for electricity connection.
How do you keep contempt case now? 410 2000. The order should not be in conflict to one another.
Yes.
Now you are placing something which you don't know.
In fact, my lord, the instructions are not provided to us, my lord. On lordship will see the impugned order. They say that since my name is not recorded in the record of rights, I am not entitled.
Something
Now,
is amiss.
yes, my lord, next time, my
Contempt
lord,
case number 410 2025.
it was against my lord.
Order dated 12/3/2026.
Lordship, I'll just place it. Lordship will kindly come to page 44 once, minutes. I'll just clear it. 44 was the interim order passed by its honorable court. Here, my lord, there was an injunction order. My lord, sorry, the after pursuant to the decree passed by the civil court, my lord, the respondent, he is not a respondent, the respondent in the particular case, my lord, Podud De, my lord, he, along with the police officials, my lord, tried to dispossess me.
But then you filed writ petition.
Yes, my lord. In fact, my lord, because the police authorities, my lord, were bent upon evicting us without, in spite of there being an order from the civil court. We approached this court. There was an injunction, the order at page 45, my lord. There was an interim order at page 47. Your lordship sees. In the meantime, the respondent authorities.
I'm trying to find out. You are making it more complicated. 2-3 নালাগে 12-3 contempt case হ্যাঁ এটা contempt case নাকি contempt case Now, come to your instruction. Well, first para. Now, come to page 56. And this has been already addressed. Where is your application?
Lord, the application, the receipt is with us.
In respect of which drug number you had applied for temporary connection?
Page 48 is the the receipt, my lord.
No, in respect of which drug number?
690, my lord.
But he is giving the instruction that you are also applying for 698.
No, my lord, that is their instruction. That is what, my lord, what I said, my lord.
What can I do with all these disputed facts?
It's not disputed, my lord.
No,
They are otherwise.
No. You are saying 690.
My lord, I'll just.
They are saying 698 application.
May I clarify?
My lord,
There-
if I may submit, my lord.
My lord, there is a decree in my favor. I have applied connection in respect of that land. Now-
This is a circle officer submitted a report.
Yes.
5th January that a plot of land in which both the applicants had applied was actually 698. What kind of report is
Yes, my lord. After I have sought for further clarification with regard to this instruction, my lord. They informed me that, my lord, Tanjit Devnath had applied in DAG number 690 and Pradyut Dey has applied in the 698. When the field verification was done, my lord, recently, so it was found that actually that DAG number is 698, not 690. Though they have applied under 690, when field verification was done, it was found that it was 698. And later they tried to find a very
circle officer report.
Well, the report is not that clear, my
No,
lord.
it
That's
is
why
part of that. It is part of the.
Oh, yes. That is in page number, my lord.
Circular lordship, page 59.
59, my lord.
Otherwise, my lord, whether.
1 minute, let me read.
Lordship.
All these facts I have recorded in the previous order.
Yes, my lord.
All these facts.
That is what I said, my lord. They are trying to confuse me. In effect, the earlier report was different.
Everybody is trying to confuse the court only.
Problem is, my lord, there is a decree in my favor, my lord.
That I have read.
Yes,
I have
Lord,
recorded, Mr.
no,
Mr.
no.
Day. I have not recorded.
No, no, Lord.
Every facts I have clearly
No, my lord,
recorded.
that is not what I am saying, my lord. The problem is, my lord, can the circle officer go beyond the decree, my lord? He is trying to call for the, my lord, the submission engineer, he is trying to call for the report. And in fact, your lordship, the DRR has also submitted a report.
Ms. Das. Submitted report through circle officer as regards existence of plot of land under DAG number 690 and 698. That's all.
Lordship,
That
in
will
fact,
clarify everything, my lord.
lordship, page 64 of the.
I can't, sitting here, I can.
No, I'm not saying.
It is a field.
Lordship, a report of the DLR is also there at page 64.
Have I not recorded everything?
Yes, it's me.
I recorded. But still the confusion is subsisting. Now question is about who is it, where is the DAG number 690 and 698? From the circle officer report, as if there is no DAG number 690.
That is what, my lord.
That is what?
The DLR.
That is what?
That
is, let him give the location of 690 and 698.
What I'm on is, my lord. The DLR says there is a 690 at page 64.
In the motion stage, Mr. R. Day, it is not possible to decide this issue.
No, lordship,
Unless
in that case,
the report from the circle officer is not received. I have recorded, I tried to solve. I tried my maximum time. I have given you maximum time to pass the previous order. Yet the issue is not solved.
In fact, my lord, lordship has inquired whether, my lord.
Mr. R. Day, Learned Counsel for the petitioner, Mr. K.P. Pathak, or Mr.
Bidas, my lord.
Bidas, Learned Standing Counsel, APDCL, for the response number 1, 3, 4, and 5. Mr. J. Hendrik, Learned Standing Counsel, Revenue Department, for the response number 2 and 6. And Ms. Udas, Learned Additional Senior Government Advocate, for the respondent number 7. Now, is it not improper to impede your rival, because he is also making claim that
I can implement, but he cannot have.
I don't know. It is for you to decide.
He cannot have.
I don't know. I don't know.
Understand?
I don't know. It is for you to decide. Later on, if he is also a claimant, we don't know. In reference to the order dated 11/3/2026, Mr. Day, Learned Counsel for the petitioner, has submitted that the existing electricity connection in the name of the petitioner with consumer number and meter number, para 6, with connected load 12 kilowatt and category domestic B is in relation to a plot of land, plot of land in relation to another plot of land covered by DAG number 814 and not the subject plot, covered by DAG number 690, in respect of which the petitioner has submitted application for temporary electricity connection. As such, the existing electricity connection has no relation with the subject matter of the litigation. Close one. So that confusion is clear. With regard to the existing electric connection, the respondent APDCL authorities have been generating bills regularly and the petitioner is paying the bill amount regularly. Para. From the instructions placed by Mr. Das, Standing Counsel, APDCL, comma, in the instruction, it is mentioned that the circle officer, Gauhati Revenue Circle, we need to make a response number 7, conducted a survey and submitted a report on 5/1/2026, stating that both the petitioner and Projyot Kumar De applied for electricity connection for the same plot of land, comma, covered by DAG number 698. Full stop. The said report is available in the case papers at Annexer
9.
9.
Page 59 below.
Full stop. From the instructions placed, it transpires that Projyot Kumar De had, along with his application, submitted land documents and power of attorney related to DAG number 698. Para. The petitioner is claiming ownership and possession of a plot of land measuring 1 kata 5 lessa, comma, covered by DAG number 63, within bracket old stroke 690, within bracket new, of NK Patta number 15, within bracket old stroke KP Patta number 116, within bracket new, situate at village Maligaon, comma, Mauja, Jalukbari, Gauhati Revenue Circle, comma, the subject plot, full stop. The response number 7, issue notice returnable on so and so, as so and so appeared and accepted. No formal notice. So, having regard to the issues raised, comma, a report from the response number 7 would be necessary after field inspection, first off. And field inspection and on the basis of revenue records, first off. And the report shall contain details about the location of the plots of land covered by drag number 690 and drag number 698. And post of placement to that effect shall also be made a part of the report.
Just the the instructions below which is there, place, my lord. Can I have a copy of it?
There is nothing.
The problem is, my lord,
Well, Post of the report that we placed before the court on the returnable date.
Yes.
The name of this is government
29th
be reflected in the respondent side. Let the existence of this be ascertained. If he is claiming 698, okay. And if you are having a separate plot, the location, then it will be provided. Well, otherwise it is a basic right.
Yes, my lord. Others, if you
7. Item 7.
Lordship, in this matter, last occasion, you also take instruction, Lordship. We're still awaiting that. I've communicated with the department, but still not this any concrete instruction, Lordship. Nothing has been coming from the department.
Busy in election or what?
Most probably, Your Lordship. Officers.
Electricity board is busy in election.
It's forest money,
Or forest.
forest. Bid will open today.
Huh?
We will open the bid today.
Not yet open. I have taken that instruction that it's not yet open yet.
10:30 the time. Opening time, perhaps. Seeing the RGC, it is most posted today, man.
What kind of work?
Construction work, man. I've given in this
Constable barrack.
page 7, I've given the nature of the work.
Okay. Okay, don't finalize then.
Status quo. Status quo.
Don't finalize. You may go for, but don't finalize.
Very well.
Yes, yes.
Heard Mr. and not learned counsel for the petition and Mr. R. Gogoi, learned standing counsel Forest Department for all the respondents. Post of. The reason for which the petition has approached this court have already been mentioned in the previous order dated 18/3/2026. On 18/3/2026, the Land Standing Council Forest Department was asked to obtain instruction as regards the contentions canvassed by the Land Council for the petitioner. Post of Mr. Gogoi. Today, Mr. Gogoi has submitted that he is yet to receive instructions. Post of. Para. Portion 2. Also, sorry. The last date of submission of bid in response to retender notice dated
28 February,
dated
28 February.
28/2/2026 was 20/03/2026 and the bids The bids, as per the retender notice, the bids are to be opened at 10:30 AM on 23/03/2026 by the Tender Evaluation Committee. Full stop. Taking note of the provisions contained in Section 26 of the Assam Public Procurement Act 2017. Before that, issue notice, returnable on immediately after vacation. As Mr. Gogoi has appeared accepted. No formal. Having regard to the position and in view of the provisions contained in Section 26 of the Assam Public Procurement Act 2017, wherein it is provided that for a cancellation of the tender process, regions are to be recorded in writing, and the decision to cancel and the reasons for decisions shall immediately be communicated to all bidders that participated in the tender process, it is ordered, in the interim, that the respondent authorities may proceed with the tender process initiated by the retender notice dated 28/2/2026, but the process shall not be finalized without the leave of the court. Returnable date.
22nd April 26. Much. Item 9. Appraisal option.
Yes, madam.
Lordship, if the name appears in the final list, Lordship, they will vote. They will vote. So as per the contention, Lordship, their names appear in the final list. It just doesn't reflect in the online portal.
Why don't you obtain instruction by tomorrow?
Lordship, today is the last day for filing.
I know.
Lordship, I'll
If
obtain.
they are sure about their voting rights, okay. Otherwise, as per the provisions of RP Act.
Lordship.
So let them have the satisfaction
Lordship.
or dissatisfaction,
Lordship,
whether they would vote or not vote,
Lordship.
or otherwise tomorrow we'll dispose of.
Lordship.
If their names are there, petition will be closed. If their names are there, not there, they will be given the opportunity to represent, and that can be decided only after election.
Lordship. Lordship.
In the final voter list, our names is there. We are in apprehension.
Digital.
Digital. Because
Let Ms. Patoki ascertain. Third, Mr. S.B. Loskor, learned counsel for the petitioners. And can you give the epic number to
yes, we have
Ms.
an
Patoki?
epic number we have already stated in the petition.
Okay, write in a piece of paper also.
Yes.
Right. And
In the presentation, we have all the
Ms. S. Kotogi, you represent?
1, 2, 4, and 5, Lordship.
Okay. Standing Council, Election Commission of India, for the respondent number 1, 2, 4, and 5. Ms. Yudas, learned additional senior government advocate Assam, for the respondent number 3. Full stop. The petitioners, 17 in number, have claimed that they are residents of village Old Solamona, Post Office, Kotamoni Bajar, District Sibhumi, Assam. Under the territorial limits of number 125, Patharkandi Legislative Assembly Constituency, LAC. The petitioners have projected that their names have been duly enrolled in the final electoral roll published on 10/2/2026 for under polling station number 177. Postal. But when they meet SARS in the official voters service portal maintained by the ECI, they could not find their name in the digital electoral database, right?
Yes.
So, where is your statement on the ECI, Epic?
My lordship,
Not there. Not there.
yes, my lordship,
Which information is necessary, Ms. Kotogi?
Lordship, the epic number.
Okay.
Annex 2, my lordship.
You write in a piece of paper.
Page
Ms.
16.
Kotogi, learn it, Standing Council, ECI.
Page 16.
Is to bring instructions so as to visit the quote whether in the digital electoral database, the petitioners' names are incorporated or not. Post stop. To facilitate the same, Mr. Losco, Learned Counsel for the petitioner, has undertaken to furnish the epic numbers to Ms. Kotogi during the course of the day. First off, release the case tomorrow.
Lordship, on Wednesday. Wednesday.
Wednesday.
I'll have.
Give the epic number.
11 and 12 similar.
Same constituency. Huh?
Same question.
Residents are same.
No, my.
Then let me check.
Village different. Village and polling station is different.
ইয়াতেও 70 নেই ৰেচিডেন্স খিনি কটামনি বাজাৰ আছে আৰু কনস্টিটুৱেন্সি সেম কনস্টিটুৱেন্সি সেম একে অৰ্ডাৰ give the epic number.
Yes.
এটো কি এটো সেম নেকি
Village different. And,
or 12. Okay. How many petitions?
12 has 65 petitions.
65 resident your Kotamoni.
this is village of Shambhunagar under content.
Shambhunagar.
Lordship, the
Police station 201 Patharkandi. Give the
Yes, ma'am.
otherwise
Yes, ma'am.
instruction will not be placed
Yes,
on
ma'am.
Wednesday.
During the course of the day only I will.
verification is as regards the online
Digital
reflecting.
database.
Lordship.
They are saying that in the
Our apprehension is that final voter list our
There
name is
might
there,
be
but
some technical
Yes, ma'am.
glitch in the online.
maybe
Lordship.
if it is technical glitch,
Lordship, but
their grievance is redressed. Only thing is that whether they will be able to vote or
yes,
not.
ma'am.
Lordship,
You find out if their names are deleted, then they have other remedies.
Lordship will find out if they appear in the final list. Lordship, they are voting otherwise.
Whether they are voting or not, I don't know whether digital database is final or
Lordship,
this thing is final. Just ensure that whether they are going to vote or not.
Lordship.
If that they are going to vote, we'll close the petition. If they are not going to vote, then they have other statutory remedy which will
Come into play.
yes, which will provide.
Lordship. Obliged.
2503. Item 10.
Lordship.
Yes.
Is it regarding?
Heard Mr. S.K. Singh, learned counsel for the petitioner. and Ms. Udas, learned additional senior government advocate for Raskona 1, 3, 4, 5, 6, and 7, and Ms. R. M. Morua, learned counsel on behalf of Mr. A. Soliha, learned planning counsel, finance department for the Raskona number 2, full stop. The petitioner has stated that he is the registered owner of a vehicle bearing registration number so and so. Full stop. Subject vehicle. It is a case of the petitioner that the subject vehicle was taken on hire by the district administration of West Bengal on various occasions, as mentioned in the table in paragraph 6 of the repetition. Full stop. After the subject vehicle were released on each occasion, the petitioner submitted his bills as per the prescribed rate. So the total amount of the bills amounted to rupees 4,16,588. So as despite repeated approaches and representations, the said amount has not yet been released. The petition is before this court by the instant requisition seeking direction to the respondent authorities to release the said amount. Forthwith issue notice returnable on so and so, as so and so has appeared accepted. No formal notice, extra copy, you need to open this.
8-5.
To ensure that the counter affidavits are filed on or before the return date.
8 May. Item 13.
May I please assume that. Lord, the petitioners are on-shop owners, Lord. Basically, Lord, we are licensees, retail licensees who procure the alcohol from the wholesale warehouses. And though we are permitted to vend the alcohol for consumption on the premises, we charge by the bottle at the maximum retail price. Now, the grievance here is, Manoj, we were issued notices to compulsorily register ourselves under the Assam Value Added Tax Act. That is the challenge.
This VAT Act is existing for alcohol,
For alcohol.
liquor only.
Yes, because
All other taxes
under-
are subject to
yes.
GST.
Yes. Now, what they've done is Article 366 of the Constitution was added to show that services, goods and services will not include alcohol. That is how VAT survives. Now, my lord, if your lordship has the VAT Act, in fact, my lord, a similar challenge was made in another writ petition, my lord, that is still pending, my lord. If your lordship desires, I'll just show what the issue here is.
What is the order?
My lord.
Similar petition already entertained.
Yes, already entertained. Interim orders have also been granted.
Yes, Mr. Gogoi, similar.
My lord, standing also, Mr. Gogoi is on legs in court number 7, my lord. He will appear in this matter.
You want to defer for some time?
My lord. Just for 5 minutes, my lord.
Let us have the order. Similarly circumstance,
Similar circumstances. Okay.
covered.
All covered, my lord. We are praying for something additionally. But what has happened is now our renewals are due, and the excise department is insisting on an NOC from the VAT authority. I mean the tax authority.
After something.
Item 55.
May it please your lordship. Also, I have received instruction in this matter. The similar matters are already lordship has already passed order.
Yes, my lord. Lordship has passed similar orders, my lord.
Ah.
For verification, it has started
Ah.
today, my lord.
Yes.
Yes.
Have you got the information?
Yes,
Where is the
Lordship.
designated place?
Mirza lordship, Mirza sir.
Mirza.
Lordship.
Also given the corrected.
Just a minute. What is this? What is this?
The chassis number is telling, my lord, or the petitioner is annexing with their petition.
Mr. Burua is that there might be suspicion regarding tampering.
That is the.
So that cloud is removed, everything will be all right.
Yes, lordship.
Is it not?
Yes.
That is your suspicion.
That is, Tata Motors gives them the all clear, we have no.
Okay, itu order code আছে.
My lord, I have a copy of it.
1549/2026.
And I have also submitted.
Without deliberating, we can proceed.
Yes.
You place your, where is Mr. Roy?
Mr. Roy.
My lord, I've informed Mrs.
Informed
Munier
but
yesterday.
he has expressed his inability to appear because because the officer said they are pro forma respondents, maybe they are not required.
No. He told me he's not requesting to appear in this matter. That's why he's not appearing. He's not requesting by the Tata Motors to appear in this matter, particular matter. So he's not appearing. I spoke to Ganesh Senior Counsel.
Okay.
I have also given a list of the differences in the order. I have handwritten or same order can be reproduced with the differences. Substantial differences.
And Mr. Read us, learning counsel for the petition. Mr. N. Bora, learning counsel for the respondent number 1, 2, and 3. And Miss M.D. Bora, standing counsel transport department for the respondent number
4, my lord.
full stop. Para. The learned counsel for the parties have submitted that in a batch of 7, how many?
7 vehicles. We have
7, no.
Only
In that,
two
in that, on that day, how many?
In that day,
Three.
there was 48 vehicles in total. 17 vehicles.
No, how many repetition?
3
Three repeats.
repetitions.
এই date to devotion, এইটোতে আছে নেকি?
My lord, I do have a copy of the other order also. my lord.
Okay, just give the repetition. Kulu? I have submitted that. On 18/3/2026. Comma. An order has been passed in a batch of writ petitions. WPC number 1549/2026,
Yes, miss.
comma WPC number
1627.
27.
and
What does that?
157.
157.
That I don't.
Lordship, I will give the number. I have the number. Make them aside as well.
this court after a deliberation.
1572, my lord.
After a deliberation on the issues involved. Comma has directives for an inspection of the number of vehicles involved in those writ petitions. Wherein so-called notices have been issued. It was at a stage of so-called or something else.
No, so the orders have been passed on the same date, common orders. So the orders passed on the same date, separate orders, but on the same date.
No, other than so-called anything else?
No,
Well,
the
it is-
individual replies and thereafter the blacklisting.
Blacklisting order.
And orders of blacklistings. The orders of blacklisting were issued. Full stop. As the petitioner hearing is similarly circumstance, comma, the counsel for the parties have submitted that a similar order be issued in the writ petition, in this writ petition also. Full stop. Para. So it will be proper that if the designated place, Mr. Roy is not there.
Yes, he has acquiesced to this proposal, but he's merely not appearing.
Okay. Good stuff. Which place? In the order,
Pradeep Shaw Mill,
dated.
Mirza, Girls School at Mirza.
On 18/3/2026. Sorry, the relevant excerpt of the order dated 18/3/2026 passed in the aforesaid three repetitions are as under para 18, 8, 9 and 10. Eight, 9, 10, 11. His case is already recorded in the previous order.
Yes, my lord.
Yes, my lord.
As the petitioner herein is similarly situated, like the petitioners in the aforesaid three petitions, comma, and impute action against the petition are in relation to two vehicles bearing registration number AS09 AC7149 and AS09 AC4205,
05.
comma, the petitioner shall place its vehicles at the designated place during the period from 24/3/2023 is already gone.
Already
At 11 AM. it
Ah.
started.
24/3/2026 to 27/3/2026. Full stop. Where the learned counsel for the parties have submitted that the designated place is
Pradeep Shaw Mill, Mirza, Girls School at Mirza.
Pradeep
Shaw
Sawmill,
Mill.
SAW,
Yes,
Lordship,
mill.
Mill,
That is sawmill,
Shaw Mill.
not automobile workshop.
It's
The
an open
space,
space.
open
Okay.
space is there.
Pradeep Sawmill,
Mirza Girls School at Mirza.
Mirza Girls School, Mirza. Okay, at 11 AM
AM.
on during the period from 24/3 to 27,
Lordship.
right? But the response number 6 shall carry out the inspection.
Response number 5, ma'am. again.
Response number 5 shall carry out the inspection of the two vehicles in terms of this order. Was to facilitate such inspection, comma, the petitioner shall furnish a copy of this order to the officers of the response number 5 at the time the two vehicles are placed for inspection.
Yes. Whether the cost payable will be subject to the further orders. too.
That is,
Already
I
there.
have recorded,
Yes.
I have extracted
That is.
paragraph 8, 9, 10, 11, right?
Yes.
It is further observed that as passed in the three petitions, comma, it is observed. It is ordered in writing that the respondent IRCL authorities shall not take any further coercive action against the petitioner and shall not enter into any transport contract in replacement of tracks of the petitioner till the return.
Lordship.
Deep notice.
Lordship, may kindly
Issue
check.
notice, okay, issue notice, returnable on so and so.
6-4.
Six. And what about 5?
5.
Difficulty is created.
My lord, a copy of this order be also served through the council appearing in the other matters.
But
That
we
can
can
be
inform my
reflected
lord.
in the order.
Yeah.
It will facilitate.
Mm.
For the purpose of service of notice, I mean, the respond number 6, comma,
Aye.
the learned counsel for the petitioner shall serve a copy of the writ petition along with its annexer to Mr. B.P. Bora, learned counsel, assisting Mr. J. Roy, learned senior counsel, who appeared on behalf of the respondent of 5 in the 3 aforesaid 3. Let us see some
Lordship.
within 2 or 3 days.
Sharma, my lord.
BP Sharma,
Yes.
assisting Mr. Roy.
Yes, ma'am.
Right. Deeply.
56. Item number 56.
Yes, Mr. Bhuya.
My lord, deletion of our names. My lord, I want to draw my lordship's attention only to one page, page 218, my lord. Page 218, my lord. My lord, what has happened after the special revision in the draft list, our names were also available in the, my lord, just before the final publication, my lord, this is the result, my lord, when we checked our name in this manner, my lord, deleted, it has came, my lord. No notice, no hearing, my lord, nothing had been provided to us, my lord. My lord, we have faced a recent, my lord, eviction process in Uriam Ghat area, my lord, in Gulaghar district, though there is an status quo order is operating by the my lord Honorable Apex Court, but during this course it had been done, my lord, in a very arbitrary and unfair manner, my lord, without providing any opportunity. We have not left that place also, my lord. We are residing here and there by somehow, my lord.
No, but what to do now?
My lord, my lordship has already passed an order.
Yes.
And we have also annexed that order, my lord, starts at page 242, my lord, and the relevant and operative part, my lord, is
But
at
only
page.
difficulty is that
The notification came into force. my
date
lord.
of nomination.
My lord.
Today.
My lord.
Yes, in another case,
My lord.
they undertook to decide because 5 days were left.
My lord.
They undertook to decide by today.
My lord.
So there is no time that that day when the
My-
petition was moved, I asked the standing council ECI to obtain instruction.
My lord.
They got the instruction next day that we will decide.
My lord.
Right here, the possibility is not there. What to do?
My lord can issue notice, my lord, and my lord can issue or
Or we can dispose of. There is no provision for us.
my lord. Then my lord, disposing of
After-
after the my lord,
After
this
that.
MCC will go, my lord, then.
You are from same locality or
My
different?
lord, we have stated in paragraphs.
Okay.
Paragraph it.
How many? Heard
My lord,
Mr.
150.
Yes, Ms. Kotogi, dispose of in the same line.
Same line, just
Right,
that
but after publication of results.
lordship,
My-
the inclusion part.
Yes. They can
Because
edit
there is a
their
third
rights. They can avail their remedy thereafter only.
Lordship.
My lord.
Heard Mr. A.R. Punya, Learned Counsel for the
Yes.
petitioners.
Numbers are available. Therefore,
Who is for respond number 1? Ms. S. Burua, Learned Central Government Counsel for the respond number 1. Ms. S. Kotoku, Learned Standing Counsel, Election Commission of India for the respond number 2,
2, 4,
4,
6.
6. Ms. Ildas, Learned Additional Senior Government Advocate for the respondent number 4. Sorry, 1. Oh, sorry, 3. Respondent number 3 and 7. So Kotogi is 2, 4, 5 and 6. Who represent respond number 6?
I am, Lordship.
Okay. Kotogi Kotogi
246.
4, 6, not 5.
No, Your Lordship, that's DC, Your Lordship.
Okay. Then U does 3, 5, 7, 8, 9 and 10. Full stop. Para. The petitioners, comma, 1,
54.
50 number. Page 243, that's right. Para number 2. Not from the same locality.
Is surrounding Oriamghat, 3 villages are there, my lord. We have
The
mentioned it.
petitioners
My lord.
have stated that village or what? Please, can you write down the name of the villages?
My lord, I will.
Just in a piece
My
of
lord,
paper.
my lord. From
They are residents of villages named under within district Gauhati
District of Golaghat in Oriamghat area, my lord.
for a long time.
My lord.
Full stop. They have further stated that for a long period of time, they have been casting their hopes in both state legislative assembly elections and parliamentary elections by virtue of enrollment of their names as voters in the electoral rolls. All the petitioners have claimed that all of them had cast. This is grammatical mistake. Casted. It should not be casted. Cast. CAST, huh? Votes in the previous elections to the state as legislative assembly and parliament as voters from number.
My lord, Sorupathar Legislative Assembly constituency.
Porupathar
What's the number?
Legislative Assembly constituency within bracket LAC district
107, my lord. 107.
107.
Sorupathar Legislative Assembly constituency.
The petitioners were also issued electors' photo identity cards much earlier by the Election Commission of India. They issue, ECI issue, EPIC. You are on the strength of same Supreme Court order.
Yes, my lord. This Abdul
Okay.
Khalek's and other connected.
Mr. Mia, Learned Counsel appearing for the petition has submitted that the petitions have come to learn that the electoral rules published after the electoral rules published after a recent exercise of special revision initiated by the Election Commission of India, with page.
Page, my lord.
The word
Deleted.
quote unquote deleted are marked, meaning thereby they are not included in the electoral rules. Full stop. Page 243 আছে হ্যাঁ এইখিনি ওয়াটারমার্ক লিখে দিব ওয়াটারমার্ক পেন্সিল কিনে দিয়া খিনি হ্যাঁ Eviction drive carried out in and around,
My lord, from the month of September 2025.
carried out during
The month of September, my lord, 2025.
in and around area
My lord, Uriam Ghat, my lord.
Uriam Ghat.
My lord. The district of Golaghat, my lord.
I think this is not chapter 10. This is
No, no,
forest.
This is
Forest.
Forest land, my lord.
Reserve forest area.
My lord.
That is allegation.
That is the allegation, my lord. That is Nambor and Doyang Reserve Forest, my lord.
Number. Reserve forest. And
Doyang.
Doyang.
my lord.
Forests are declared under what act?
The Forest Conservation Act.
I think forest, no. Assam Forest Regulation.
My lord, my lord.
Assam Forest Regulation and
1580 was
1897 or silos
my lord. It is long back, 1950 declared for
regulation.
judgment to the first.
1887 and
1887.
1887 or 97?
No, my lord,
87.
87, my lord.
1887.
My lord, because these are came up before, my lord, 1950. My lord may be pleased to find.
Confining
47.
ownership to
Page number, Abdul Khalid judgment.
Notifying.
My lord may be pleased to find at page 47.
So, what is your claim?
My lord, our claim is that, my lord, we are not within the earmarked boundary, my lord.
Okay. Petitioners have claimed that here cases of incidents do not fall within So your claim is that your places of residence do not fall within the boundaries of the two reserve forests.
My lord. And secondly, my lord, as the Honorable Apex Court
that
my
is,
lord, has held directed to maintain status quo.
So that is a number of litigation ensued. Lastly, the Honorable Supreme Court in that is contempt petition or Abdul Khalid.
No, Abdul Khalid case, my lord.
This contempt petition is applicable.
Contempt petition is also there, my lord.
Contempt petition is applicable.
My lord, it is.
In various orders,
My lord.
including in contempt petition.
Contempt petition is for, my lord, chapter 10 area, my lord.
Okay.
For the forest area, my lord.
Okay. This is to be deleted from the previous order.
My lord.
What is to be written?
Now, my lord, for the forest area, my lord, a guideline has been formulated by the Honorable Apex Court in Abdul Khalik's SLP, my lord, wherein it had been directed that a committee is required to be constituted and the committee will decide the claim of this type of petitioners, my lord. Until the issue is decided by the committee, there is a direction for maintaining status quo, my lord.
Okay.
We have
Okay.
annexed that order, my lord, at page 45.
এটা মই এটা ষ্টাৰ দি থৈছো ষ্টাৰ হা ষ্টাৰত আপুনি গেপ ৰাখি থৈ দিব পেজ 244 ষ্টাৰ এটা আছে হা So you are still residing according to you?
Some, no, my lord, some of the persons' house already been demolished, but they are residing in the area, my lord, by managing temporary structures, my lord.
So you are still in within
Yes,
that Horupathar LLC?
LSC.
You were there when I disposed of
No, you're not.
Atia's case,
The
Mr. Atia. Okay, I'll be disposing of in similar line, but with the necessary changes. And just the timeline is over for the time being. Today is the last date.
I can understand.
So I'll pass it on.
Deeply obliged.
Need some attention.
Fine.
So after
After
that,
the-
you take up in the right earnest to decide.
Lordship,
That I'll observe.
Lordship,
And within the timeline.
Lordship.
Fine. Obliged. Deeply.
I'll pass it.
Madam of the petition nalag.
Some more intake order, Mr. Decca is pressing.
But my lord, here, one
Perhaps-
thing, my lord, they have responded to the so-called. And that apart, my lord, whatever they, now they are pleading, my lord, they will have to challenge the rule, my lord, the amended part, my lord. Because the power, the jurisdiction is there, my lord, in that particular, my lord, amended part.
Mr. Decca is saying that there is already an interim order in similarly situated case.
My lord.
And where
No
is the,
coercive action, my lord.
and secondly, is that without insisting for NOC
Yes.
renewal
Renewal.
provisionally.
That part, of course, my lord, renewal is of the, my lord.
Provisional.
Yes. Excise. Go for it.
Case 190.
Yes, please.
Huh?
190. 190, 7, point number 7.
Point number 7.
Yes.
Yes, Mr. Without insisting for NOC,
My lord.
other 6 they will comply with
No, we'll comply with the rest.
provisional.
Provision. Will be subject to outcome.
Okay. Hard. Will not go in detail. We'll put it with along with that petition. Right? We'll not go in detail all this. Writing all this similarly situated.
That will
Mr. Gogoi
My lord.
or Mr. B.D. Decca, Learned Counsel for the petitioner. Mr. B. Gogoi, Learned Additional Advocate General Assam, of the respondent number 1, 2, 3, 4. Mr. 6. Sorry,
6.
1, 2, 3, 4.
5.
And Mr. R. Gogoi, Learned Standing Counsel, Excise Department, for the respondent number 5, 6, and 7. First from the petitions. 12 in number, comma, have approached this court stating that they have a common cause of action the espouse, postal. All the petitioners are IMFL, quote unquote, on shop retail licenses are engaged in the business of potable liquor under licenses granted under the Assam Excise Act 2000 as amended and, read with the Assam Excise Rules, 2016, as amended for retail brand of liquor to be consumed on the premises. Postal. The petitioners have stated that they are aggrieved by the so-called notices, assessment notices issued by the respondent number 6 or respondent number.
Show cause notices issued by respondent number.
Show cause notices issued. Show cause notices
Four.
annexed as
Annexure B series,
B
page
series to the petition, issued by the respondent number 4, as well as the assessment notices, annexed at
page 128.
annexed
So,
as
C series.
annexed as C series, issued by the respondent number.
Same, my lord.
Annexure E.
E series. E series, my lord. Superintendent of Taxes.
Respondent number
4.
4. By the state proposed notices, stroke assessment notices, valuated tax has been sought to be levied and has been sought to be levied upon the petitioner. Timing the same as illegal and without jurisdiction. So timing the same as illegal, without jurisdiction, contrary to the statutory schemes, the petitioners have approached this court by the instant petition. First up, Mr. Dekal and counsel for the petitioner has submitted that the petitioners are similarly situated like the petitioners in the petition, WPC number 326/2026, wherein notices have already been issued to the respondents by an order dated 22/1/2026, and the respondents are yet to file their counter affidavits. Full stop. The learned counsel appearing for the respondents, I think that the petitioners are similarly situated like the petitioners in WBC number 3/2026, 326/2026. Let notice be issued. The notice is made returnable on so and so. As so and so has appeared. Accepting notice. This. This. The learned counsel for the parties are also part of my interview. Considering the fact that the petition, 326/2026, an interim order is passed. Similarly, in this petition, it is ordered that till the returnable date, no coercive action shall be taken against the petition on the basis of the impugned show cause notices within bracket Annexure B series and the assessment notices within bracket Annexure E series till the returnable date. Full stop. The learned counsel for the petitioner has submitted that in the meantime, notices have been issued to the petitioners. No, meantime, the petitioners are required to submit their applications for renewal of their license for the financial year 2026-2027. Full stop. The response number 7 by an office letter dated 28/1/2026 has asked has asked the retail licenses, IMF on retail licenses, to submit their proposal for renewal in a prescribed format along with 7 number of documents. Full stop. One of the documents to be submitted for renewal is NOC from jurisdictional tax officer. Full stop. As such an NOC would be would not be possible for the IMFL on licenses to submit in view of the challenges made in this petition, the prayer is made on behalf of the petitioner to allow them to submit their renewal licenses. Submit the application in the prescribed format. Along with the other 6 documents mentioned in the office letter dated 28/1/2026. And the petitioners have submitted that the response number 7 shall process the application for renewal at this stage without insisting for the NOC from the petitioners. Full stop. Having regard to the facts and circumstances of case, it is ordered in the interim that the response number 7, if the petitioners submit their renewal applications complying with the other conditions mentioned in the office letter dated 28/1/2026, the response number 7 shall process the application for renewal. Process the application, renewal applications of the petitioner for renewal in a provision manner without insisting for the NOC from the jurisdictional tax officer, so as to enable the petitioner to continue with their business.
But that no coercive action part which figures in the other order, I'm not sure whether your lordship has.
I have already passed things. Additionally, I have said.
But perhaps annexure E would be annexure F series, the demand.
Okay, annexure F. E no, annexure F. Is this repetition along with WBC number
326 of 26.
The respondents shall bring their stand. by counter affidavits on or before the return date.
Deeply obliged.
8/5, 8th May. Orders stay vacating, items 14 and 15.
Wait, please, this one.
16.
The IA has been filed for vacation modification of my lord's order dated 16/2/2026, my lord.
Where is that annex, sir?
My lords, at page 119 of the IA, whereby infrastructure project has been stayed, my lord.
119.
Page 119 of the IA, my lords.
Okay, let me read.
My lords.
Yes, Mr. Bora.
My lord. My lord, because the stay vacating petition in my humble submission, my lord, entire matter may be taken up, my lord. Some other day, my lord. Let the PWD also file their affidavit
That-
response, my lord. Because
That can be done, my lords, but the only predicament is, my lords, that work is time bound, my lords. There's a deadline, and the date of completion is 31/3, my lords. Infinite.
Yes, Mr. Nayak.
And don't prejudice.
I received one letter from the department lordship, wherein they have asked me to pray before your lordship for extension of time for filing my affidavit lordship. That is one aspect. Another aspect is there, one judgment is there at page 33 lordship.
the petition.
So this sheet of
The
application number
If only instructions is sufficient, you take instruction, we can take up the entire thing on Thursday.
Thursday, it will not be, may not be possible.
And my lords,
Lordship will grant me 2 weeks time to file my.
Written instructions.
Yes, lordship. That I have not yet received.
If they, you can get it written instructions by Thursday, we can take it up.
Yes. Thursday.
Instead of affidavit.
He have asked me for 2 weeks time.
the last date is 31/3/2026 for completion of this. My lord comes to paragraph, page 111. my lord.
PWD is itself seeking time.
Yes, yes, my lord, just one aspect, if my lord
I have
considers,
not
my lord.
read, I have not read what order I have passed.
Yes,
Let
yes.
me have a look.
Yes,
Just give me
My
two,
lord.
3 minutes, 2-3 minutes.
Yes. Page 119, my lord.
Okay.
Engineer or affidavit to apply. My question. Yeah. 112. 112.
Yes.
Yes. Yes, my lord,
What is your basis for
my lord has,
vacating the interim
yes,
order?
yes, my lords had.
Otherwise, single bench
Exactly.
has
So
say.
some facts are not placed, my lord. If I give a
No,
timeline
that's
of
okay,
the
okay.
events, my lord.
But
it'll be-
there is a judgment,
Exactly, exactly.
right, of the single bench,
Yes, man.
right?
Right, man.
That thereafter, who somebody has said that original contract was never
Exactly.
legally terminated.
Right. That is also correct.
Some opinion has been made,
Yes.
which is not in conformity
Against
with
the
the,
judicial imprimatur, what my lordship has
yes,
stated.
yes.
Now, my lord,
Thereafter,
perhaps that finding came because some facts are not placed. My lord. What had happened, my lord? The same judgment, which my lord says is in violation of the work should not be, should have, work was granted in violation of the earlier order 3011. The same judgment held, my lord, that the allotment of the work to the petitioner for the remaining work was not at all proper, and there was a direction in the judgment to conduct an inquiry. Now, what had happened? What had happened thereafter, my lords? Pursuant to that judgment, my lords, the governor of Assam had constituted an inquiry committee. If my lord kindly comes to the kindly come to page number 125 of the IA, my lord. Page 125. My lord has it, my lord. Page 125. I won't trouble my lords with the entire agenda, my lords. If my lord comes to the page 126,
yes,
hereby appointed inquiry officer, my lord, the chief engineer of the department was appointed as the inquiry officer to conduct a de novo inquiry in the charges framed against Sri Chamed Ali, executive engineer, the executive engineer PWD Patharkandi, and Sri Baldev Sinha so and so under suspension so and so by show cause number so and respectively, to find out the role of other officers involved in the anomalies, including beneficiaries like contractors of the balance work, and also to find out whether the cancellation of contract with original contractor is valid or not in view of the alleged manipulation. My lord, kindly take note. In serving notices prior to cancellation dated so and so, Kushal Deka so and so, PWD so and so.
where is the judgment?
Yes. Thereafter, the inquiry.
Where is the judgment?
Judgment, my lords. Judgment page 59, my lords.
15.
My lord is referring to the
Just a
3011.
minute.
Yes.
Where is that?
Page
says
77. 77.
77.
May I read, my lord? Paragraph 51.
Yes.
Yes. In view of the above discussions, this court is of the opinion that while the first challenge pertaining to termination of contract is not liable to be interfered with, and the second aspect of allotting the balance work to the respondent number 6, who's the present petitioner, my lords, would require certain intervention from this court, as it involves a huge amount of public money, and the work in question is undoubtedly of immense public importance. However, since questions of facts are involved, this court cannot play the role of a primary authority. At the same time, there have been glaring anomalies in the said allotment, as would reveal from the fact-finding inquiry of the additional chief engineer so-and-so dated so-and-so. Appropriate action be taken against the erring officials, more particularly the respondent number 5, the executive engineer, against whom specific allegations have been made, which are also substantiated in the inquiry report. Appropriate steps may be also taken against any other officials involved, including beneficiaries, in view of the prima facie finding that in the inquiry report dated 6/4/2022, it is needless to state that the action to be taken has to be strictly in accordance with law by giving a fair opportunity to the persons arraigned.
Now come to page
Yes.
126.
126.
Last but 3 line.
Yes.
Also to find out
Yes,
as to whether cancellation of contract with original contractor is valid.
yes, yes, yes.
How can this be a scope?
My lord,
Yes, valid or invalid, whatever.
yes, if my lord, sorry,
The judgment was appealed.
yes,
Appeal was withdrawn.
yes. Why, I'll submit why, my lord, why it was withdrawn.
No, tell me this explanation.
Yes,
Find out as to whether cancellation of contract with original contractor is valid.
yes,
This lie or not.
yes. Yes, I'll come to
Now
that.
come to page paragraph
77, page 77.
77. Before that, perhaps there is a finding.
Yes.
There will be definitely finding why it is not interfered with.
Which,
Hmm?
which was not interfered with, my lord.
Page 77.
Yes, yes.
Why, in view of the above discussion, court is opinion that termination of contract is not liable to be interfered with.
Yes.
So what is the discussion?
Yes,
Where is the discussion?
Yes, exactly. I'll come to the discussions, my lord. That only on 2 grounds it was, my lord.
No, where is the discussion?
Yes, yes. Just my lord would give me a moment, my lord. The first ground is, my lord would find at page 50, paragraph, page 15, the
No,
internal
you put
page
discussion.
41. Yes, the discussion, my lord.
Page?
Internal page 15, my lord. Page 73,
Page
paragraph
70.
41.
Page 73.
Yes. 41 paragraph. The internal page of the judgment is 15. Paragraph 41. The learned single judge never went to the merit of the matter, my lord.
So the department official will go into the merit.
No, my lord. My lord, read it. My lord, read why it was set aside.
Order of termination dated so-and-so was preceded by a number of opportunities, including so-called notice.
Yes. Yes.
No noticeable improvement could be achieved by the petitioner.
Yes. Page 41.
So it cannot be there has been violation of principle natures and reason for issuing permission are genuine and relevant.
Yes.
Right? That has been held.
Yes. Now, para 41, my lord. In view of the aforesaid decision, it is apparent that the order of termination dated so-and-so was preceded by a number of opportunities. My lord would note that. Number of opportunities, including show cause notices. However, it appears that in spite of the numerous opportunities, no noticeable improvement could be achieved by the petitioner. Therefore, it cannot be said that there has been any violation of the principles of natural justice. The first is principle of natural justice. The second ground, the challenge, namely the authority of the executive engineer to issue termination order. It is the contention that such power is vested in the chief engineer of the department. It is further contended that the letter from which such powers have been sought to be delegated is not part of the contract and therefore could not have been taken into account. On the other hand, the records of the case would show that all along the correspondence with the petitioner was being made by the executive engineer, including show cause notices, my lords. The decision to terminate the contract is not a decision of a particular officer, but the department in the case, it is seen that the said decision has been conveyed by the executive engineer. In the considered opinion of this court, though the same may be held to be deviation, such deviation would not go to the root of the case in as much as it is the decision of the department which has been conveyed. The court cannot also ignore the communication dated so-and-so issued by the chief engineer, PWD Roads, giving authority to the executive engineer to issue termination notices. Other pertinent factor is that the said communication is with regard to all PMGSY works and the present work is also under PMGSY and therefore it cannot be said that the communication is wholly out of context. Now the learned single judge refused to interfere with the order of termination on 2 grounds, my lord, that natural justice was complied with, and second, the contention that the executive engineer did not have jurisdiction was ruled out, my lord. Now, what had happened pursuant to the inquiry, my lord? It came to light, my lord, that those notices, those show cause notices were never served to the petitioner, my lord. The executive engineer was booked,
So
was penalized.
it will have called for a review, sir.
Yes, my lord.
Was it not called for a review then?
Yes, perhaps.
This order with the dismissal of the writ appeal.
Yes, yes.
Right?
Yes.
As 18 filed, whether right or wrong, it is a different thing.
Right.
Right or wrong is completely out of context now.
I totally understand. Well, if I can put it a bit differently,
But
my lord, they were
still sitting over it.
yes.
You either seek review or writ appeal. Now you have lost the right of writ appeal with the withdrawal. With the withdrawal, thereafter there is no scope for review also.
Right.
The position as it exists, I think review could have been filed earlier, and review was dismissed, and you could have preferred a writ appeal, right?
No.
But here you went for appeal,
No, my-
right? Not seeking liberty to file review.
Yes.
So review power is lost.
What had happened, I'll just, if I can put it a bit different.
But why 126 again? Why?
Yes.
To whether
David-
cancellation of
David-
contract with original contractor is valid or not? Can they sit over it?
Yes. Yes.
If we allow
Yes.
this fact-finding inquiry to sit to decide also whether the cancellation of contract with original contractor is valid or not, that has been for two reasons. Executive engineer power has been
Yes.
okay. Court said okay, it will be all right.
Exactly.
And secondly, violation of principle of natural justice. That is also done away with. Thereafter, fact-finding inquiry cannot go into that notice.
Yes.
No opportunity, no notice was served.
Now, my lord.
And where is the writ appellate order?
Yes, appellate order.
Which page?
Writ appeal, my lord, find page 106. Now, that was submitted before the learned division bench, my lord. Why we had withdrawn the appeal, my lord would kindly see.
So that does not mean that is why I said
Yes.
the judgment of the single judge is not wiped out of existence. Had it been set aside
Yes.
by the division bench and okay, you go for fact-finding inquiry, I would have accepted.
If I may kindly submit just on one point, my lord, there were two directions contained in the judgment of the division bench, my lord. First, the single bench. I'm
Let
so
us.
sorry. Yes. First, my lord.
No, one issue is settled.
Yes.
Cancellation of contract is not interfered with, and it
Not
cannot be
interfered.
read in other manner, so and so.
Not interfered. So, my lord.
So it deems to be valid.
No, my submission, my lord. The learned single judge, my lord, just refrained from interfering with the order of termination on two very technical grounds, natural justice and jurisdiction, my lord.
Whatever it is, a
Yes,
judgment.
the learned single judge never entered into the merit, and the other direction of the.
Oh, you have license to enter into merit.
No. What I'm saying.
Mister, what do you want to say?
Plus the other direction, my lord. The other direction.
Which direction?
The 3011.
Fact-finding inquiry.
Yes, you conduct an inquiry.
So, by entering into
Yes.
the fact-finding inquiry, you can also examine
Yes.
that cancellation of contract with original contractor is valid or not.
When the chief engineer inquired into the matter, a lot of anomalies were found, and they were.
Sir, tell me the point of law.
Forgery and fraud, my lord, with vicious.
Whatever point of law.
Yes. Yes. Yes.
Whatever is it is not that the court is not always correct. Right. It may be right or wrong.
Right.
Right. But so far as one issue has been concluded,
Right.
that cancellation of the contract,
Exactly.
court is not going to interfere with
Yes.
for two reasons. These are the two reasons, right? So that by anyhow, that cannot be changed into this, that whether the cancellation of contract with the original contractor is valid or not.
Yes.
That cannot be the scope of the or terms of reference of the fact-finding inquiry. Yes, to find guilt against officials,
Yes.
you can go for it.
Yes.
That, that. But can you examine
Now.
this validity when it received the court's judgment, whether right or wrong, that is a different issue. And if we let us read the division bench judgment.
Yes. Page 108, my lord. We have heard so-and-so learned senior advocate, appellant, and Mr. So-and-so of the government so-and-so. The appellant was awarded a contract for construction of a road under PMGSY package number so-and-so. He carried out substantial construction, completing approximately 5.3 kilometers road out of 5.43 kilometer, which in fact was never disputed. However, during the period when the pandemic had set in, the work had slowed down, and by that time the contract period had expired. It was the case of the appellant that despite several reminders, the respondent for extension for time for concluding the work, no order was passed. However, to the dismay of the appellant,
Sometimes in December 2020, his contract was terminated, saddling him with a penalty of 20% and with a direction to cease the work immediately. This order was passed without any notice to the appellant. The order presumably was passed by the executive engineer and not the chief engineer, who was the competent authority to pass an order. The submission of the learned counsel for the appellant was contested by DNAT by the learned senior government advocate that the power to take a decision in that regard has been delegated to the executive engineer. Nonetheless, the matter went before the court. The learned single judge found no folly with the decision of the respondents in cancelling the contract of the appellant. However, on account of various startling facts which have been brought to the notice of the court by the appellant regarding selection of a new concessionaire without indicating the portion of work which was to be completed by him, and release a huge amount of money towards bills raised by such person without the work having been started by him. An enquiry was directed by the learned single judge. Pursuant to the enquiry, the allegations leveled against the appellant was found to be correct. My allegations were found to be correct.
Right.
The respondents, in their wisdom, recalled the cancellation order and directed the executive engineer to entrust the balance work to the appellant by communication dated 7/8/2025. The executive engineer by communication dated 19/8/2025 was asked to ask the appellant to mobilize his sources and intimate the respondents about the date of resumption of. I'll just pause for a moment. These two orders, my lords, it was challenged in the first writ petition by the petitioner, and there was no stay, my lords. The interim order was only no coercive action against the petitioners, but the work was not stayed. These two orders, 7/8. Subsequently, it has been stayed by way of the second writ petition, my lord. The appellant now is in the process of mobilizing his resources and would make effective correspondence with the respondents regarding the date on which the work shall be resumed and the time span when it will be completed. In view of such decision of the respondents in entrusting the balance work again to the appellant, the learned senior advocate for the appellant seeks to withdraw this appeal. Now, during the pendency of the writ appeal, the department, pursuant to the inquiry which was directed to be conducted.
This part has been directed.
Yes.
Page 109. However, on account of various startling facts,
Yes.
fact-finding inquiry
Yes.
has been directed by the single judge.
Now, my lords,
And correct.
Yes. Now, my lords, the conduct of the petitioner in their pleadings, they state, my lords, they started working even before the NIT was issued for the balance work. That is their pleaded stand. And they say all throughout that we have completed the work. My only submission now is, my lord, if they have completed the work, how will it?
Where is 7/8/2025 and 19/8/2025?
Yes. Order, no? 7/8/7/8. My lord's page 98 of the.
I'll look into it.
No, lord, 7/8 is 99. I'm so sorry. 99.
Just a minute.
Yes, ma'am.
Let us see the second part of the order
Yes.
of the single judge.
Page 77 again. 77. Large scale anomalies were there, ma'am. Page 77, paragraph 51.
So this part says about fact-finding inquiry and appropriate action to be taken against the erring officials And more particularly, respond number 5, perhaps the executive engineer as well as the beneficiaries. Beneficiaries may be the petitioner
Yes,
also.
now the next
Right.
order, my lord. Page,
Right.
yes,
Page 77.
yes, page 102 again, both the orders were challenged in the first writ petition, my lord. And there was no interim granted, my lord, only no coercive action. There were 4 orders which were challenged, my lord. After the inquiry, it came to light that the petitioner has siphoned off almost 2 crores rupees, my lord, without doing any work. The money was allotted to them after 1 day of the.
No.
Yes. Yes. In connivance.
That is one aspect.
Yes.
The
page 102, 102.
No, 1 minute, sir.
Sorry.
120.
Page 120, my lord.
In the 120, page 120.
Yes.
It is the order dated 19/1/2026 and 28/1/2026.
Yes.
Are made subject matter of challenge.
Yes.
Right.
Yes, my lord.
And therein the reference of this earlier or 2 orders were there.
Yes.
Now, tell me, in 102 or what you are saying, that was it part of the challenge?
Page 102. Yes.
104. 104. Could not be because these 2 orders are subsequent.
No.
Page 104.
Page 104.
No stay. You are saying that no stay.
Just 1 minute, my lord.
104.
Exit.
This is a repetition of 2000.
Now I'll
Simple. 4887 2020 petition of 2025.
Yes.
And page 120.
Yes.
Paragraph 2, first line.
Yes.
2 office letters, 19/1/2026 and 28/1/2000.
That is subject matter of the second writ petition.
Yes. That could not have been.
Yes. No.
And court has passed this order on the basis of the challenge made to
these 2 orders.
Right.
These 2 orders.
After the court is wondering.
Yes.
After termination of the work, that is whether he had done allegation, whatever misappropriation, whatever is there. But court had terminated the work.
Court did not terminate it. Court refused.
Court had accepted termination of the work.
Yes.
Right. And division means you made submission that I am in the process of getting it.
No. Division bench, when the matter was pending, these 2 orders, my lords, the order dated 7/8/25 and 19.
We withdraw it.
Yes.
We withdraw it.
Which directed us to continue.
Which is open to challenge.
Because we could not have proceeded after our prayers were
That is
addressed.
that your risk and cost.
Our prayers.
That is your risk and cost.
Now another
involved. Now here is a question court is wondering after the court in a judgment has said that termination of the work with the petitioner was valid. 2 reasons were there.
Yes.
Opportunities granted and that executive engineer had deemed authority, whatever. Right. And court is wondering how the PWD in their wisdom have allowed you to start the contract again. I am not on that petitioner's alleged irregularities or whatever, siphoning of money. I am on the point that how after a termination has been approved, whatever, of that, again they in their own wisdom has decided to extend the benefit to the petitioner when court has said that this, what is that? Valid means you had erred, you had defaulted in executing the contract work. So, what is their explanation to award the same contract work? That should come from Mr. Nayak. You cannot justify. It is like if this petitioner is extended benefit illegally without, say, valid tender process to award the work, right? Then once it is terminated, how can they, without issuing tender, how can they give you?
Yes.
How can they give you? That is the only question.
I'll just
I
answer.
don't find.
answer-
Yes,
just
Mr.
two
Nayak,
points.
please answer this. How can you give it to the defaulted contractor?
For us, facts to that point, Lordship, I will obtain instruction, but two, three things are very important, Lordship.
No, simple. My issue is simple for us.
Yes.
Once a contract was awarded, right?
I
Right or wrong?
understood, Lordship, I understood.
You issued
Yes.
a termination order.
And that has
That
not,
order was challenged. And court had found that termination order was valid on two counts, whatever count.
first
But
thing.
it is termination. It
Yes.
attained finality.
Yes, Lordship.
Ultimately, it was not set aside by the court.
Yes.
So remaining part of the contract work has to be executed
Yes.
by somebody. If something is alleged,
Lordship, one very important point lies there also, Lordship. If Lordship comes to the.
court has allowed you to award the contract.
No,
without
my submission, I'm entirely on the basis of record, Lordship. If Lordship comes to page 51 of the writ petition, Lordship. Lordship, there was one earlier report by the chief engineer. Lordship. And there it has been specifically mentioned that the petitioner has completed the work. And that report was before the learned single judge, Lordship. That question is before me also. Once the report has been, Lordship, at page 51 of the writ petition, Lordship.
Writ petition.
Yes, Lordship. It is 837/2006, 26. Page 51, Lordship, one paragraph 16 has been quoted there from the report. So Lordship will find that specific line. Though the work has been completed, date of completion is also there. Final bill has not been prepared and payment could not be paid. Lordship, in this case, Lordship, there was one earlier order, Lordship, wherein direction was issued to release 50% of the amount, Lordship, to the writ petitioner. That has already been paid.
So how can this,
That is what I am also thinking, Lordship. That is my question, Lordship. I am going to take that instruction from the department.
My lord, in the writ appeal also, the chief engineer has filed one affidavit saying that the entire work has been completed. In the writ appeal, my lord, that affidavit.
Where are those letters? 19/1/2026 and 28/1/2026, Annex 15 and 16.
26 order return.
That order, my lord, at page 121 of the writ petition.
So basically, it is premised on the basis that submission was made that the respondents have recalled their decision.
Yes.
Right, recalled.
Yes. Now, I don't know.
Cancellation order. After receiving, that is my question, judicial imprimatur on the termination order.
Yes.
Can the PWD department can sit over it and to recall the cancellation order?
Yes.
That is one, Lordship. Secondly, Lordship.
As simple as I don't understand.
Yes, exactly, Lord.
I don't understand all this jigmarole.
Learned friend is arguing for the petitioner.
I'm arguing for the government.
Which department is allotting.
No, I'm arguing for the
Tell me, Mr. Mohanto. Tell me, Mr. Mohanto. After receiving the judgment and order, you made some submission before the appellate court.
Yes.
Right? And wanted to withdraw.
No, some submission. Because the orders dated 7/8/2025.
Anything else, Mr.?
19.
Not required, at least for this vacation of the interim order is nothing. Not required.
My lord, I'll just
Anything
answer-
else, please?
Yes, just 2 points. First, I'll answer, my lord, why the department recalled the order, my lord. That because of the inquiry.
Tell me on the law, why is not required?
Yes.
Why is not required?
Yes, yes.
When a single bench has said and the division bench order wherein you withdraw the challenge to the judgment of a single judge,
Right.
right?
Right.
How the PWD department or chief engineer or commissioner can recall the termination order without seeking any kind of leave or review from the court?
I've understood.
Is it not overreach?
It
And
can-
whether court can close eyes on it?
Yes, yes. Yes. Yes.
As simple as that. I don't understand all this
Yes. Yes.
going around the bushes.
Right, right.
As
I've
simple
totally
as that. As simple as
Whether
that.
there ought to have been a leave by the department before allowing me to.
Yes,
resume
they
the
could
work.
have, yes, I would have understood. I am not, whatever he had done, he should be punished. This court is only concerned with that
Yes.
after the single judge judgment, which has not been, I have said, it is not wiped out of existence,
Right, my lord.
right?
Yes.
So, in such situation, how can the department recall that cancellation order when the court has already approved it?
Yes. My lord, sir, yes.
Either review or
I've totally, absolutely understood my lord's contention. I'll just answer to that, my lord. Let's, the pertinent, if there's a legal, my lord, the legal issue, what has been raised by my lords, that can always be, my lord, it's an arguable point, my lord, that has to be argued. My lord, but
so far, my concern is that department's overreach is not arguable. As simple as that.
Exactly.
19-1-2026 and 28-1-2026 is a case of overreach.
Right. So my only submission, my lord, that this aspect may be kept open. But in the meantime, lordship would also see.
No,
my lord,
I'll hold it finally so that you can have all the avenues open.
my lord, just one.
Am I clear? At least my understanding is clear. My thought is clear. So that you can have it reversed before
My lord.
have.
Just one more point I'll add, and
So that-
my lord,
No, as simple as
the
that.
injunction or the stay would be in violation of section 20A of the specific release. my
Okay,
lord.
you go and argue.
Infrastructure project. That's my one.
You go and argue before all other forum.
And
I am not into that overreach.
right. my lord.
This overreach is not.
Yes, yes. That, my lord, first.
Court is only concerned with this
My
overreach.
lord, the stand of the petitioner is that he has already completed
And
the work.
they are also sitting over everywhere. They now the executive overreach is everywhere. Page 126.
Yes.
To find out whether the cancellation of contract with the original contractor is valid or not. Once court has held it, how can they take it within their terms of reference? Executive engineer, chief engineer, is it a joke? Is it a joke?
My lord.
Let them, Mr. Nayak answer.
Well, he's
Let him answer in the response.
in-
No, we are not into this petitioner's alleged irregularities.
yes.
We are only concerned with their overreach.
Right, right. Right. If
I am not into it.
If I may
Everybody should be punished.
if I may suggest one thing, just one thing, my lord, just one thing. My lord, after all, it's an infrastructure project. Now it is the contention of the petitioners that they have already completed the work.
Right.
And after the inquiry, it has come to light, no, the work has not been finished. Now, for the sake of
Those are disputed questions.
yes, for the sake of public interest, let me continue. This can be decided whether if why not. What my learned friend is
I am
submitting.
not, I am
instruction-
submitting in the interest of justice.
Well, page-
Or vacating
This cannot
interim
be
order.
allowed.
I am not finding it vacating the interim order. This petition, this interlocutory application is found.
See for a moment. What is the instruction? Page 111, kindly one. The project would suffer, my lord.
As to.
I come back at 2 months.
Oh, you are so concerned with project, let the department take care of it. If you are concerned with that, let the department take care of it, right? A contractor, right? A contractor is concerned with public project.
Well, Lordship may
Mr.
kindly record my learned friend's statement because learned friend's statement may be recorded.
No, we are
Submitting
into,
against the petitioner.
we are into overreach.
Hesitating.
Well, whereas the orders, the
Mr. Mohanto,
department is.
Mr. Mohanto, you justify your overreach.
Well, I'll justify if I at two, maybe if I can, but it's.
No, that is close. Your option is there. I have said. I am not concerned with that because we are finding overreach in every case. This executive overreach.
Right. That issue is there, Malaj.
And I am not in support of that.
This resumption of work has been issued by PWD now.
No, we are not. We are into the validity of the order, Mr.
Right.
And my that order's vulnerability you have questioned. Right. So this is 19/1/26 and 28/1/2026. We are not concerned with earlier orders. Earlier orders passed in a writ petition, where these orders were not challenged. We'll come up, I will sit at 2 o'clock. When this writ petitioner was awarded the contract work for the remaining part?
Yes. My lord, the contract for the remaining work, if my lord takes up the first writ petition, my lord, 4887. My lord, we take down the notes. The purported NIT, which was never published, my lord, it came to light, was on 1/2/2021.
Page?
My lord would take up the writ petition.
4887.
Page 12.
No.
WPC 488725. That narration is there, my lord. Page 12.
Page 12.
12, my lord. Five, 6 lines from the top, my lord. It starts with after a long discussion. My lord, has it? That's the narration of the petitioner. After a long discussion, the higher authorities verbally instructed the petitioner to execute the balance work of AS 13278 on 11/12/2022, since it was the full working season and PMGSY works were time-bound flagship program of the Government of India. Accordingly, the petitioner started to execute the balance work with effect from 11/12/2020.
Is there any independent challenge from this applicant to this award of contract work?
Did we challenge the award of the contract work?
Is there any independent challenge from the applicant?
No, not from the applicant.
Not from the applicant.
No independent challenge because we could not have challenged because that was again terminated. His work was terminated. If my lord comes to para 12, my lordship would see that before even the NIT was floated for the remaining work, he was verbally allowed to work, and after the award of tender, within 2 days, 1.91 crores was released, my lord. Para 12.
Right. But is there any challenge to this by the applicant?
My lord?
Is there any challenge to this particular?
Not by the applicant because the orders of the department are there. They are challenging it, in fact, my lord. They are the petitioners are challenging it because a recovery order is there for recovering that 1.91 CR. Plus, my resumption of work is there, which they are challenging, my lord. So the applicant need not challenge it independently, my lord. Now, my lord, the pointed query, my lord, if I can, if I'm formulating it correctly, is that after the single judge had held, my lord, that the cancellation of the work was not liable to be interfered, whether the department was justified in reallocating the work to the applicant. That's the pertinent. Now, my lord, to answer that, the first answer would be, my lord, the impugn decision does not amount to award of a fresh tender, my lord. It only in favor of the original tenderer, but merely restores the tender process, my lord, which after coming to light was vitiated. The cancellation itself was vitiated by fraud. Now, my lord, if I may say, my lord, with the deepest respect, my lord, the action of reallocating the work to the applicant, the respondent number 6, was in strict compliance of the judgment and order dated 30/11/2025. Why I say so, my lords? The department conducted a detailed inquiry and had taken consequential orders and consequential decisions on the basis of the findings. And what were the findings, my lords? My lord is aware fraud vitiates everything, my lords. Once the very foundation of the earlier cancellation was found to be vitiated by fraud, parties must be restored to their
No,
original position.
what is the terms of reference of the fact-finding inquiry?
Yes, yes, yes.
Question is that the question is to take appropriate action, but appropriate action does not mean that ignoring the binding order of the court, that you ignore it and you recall it when a judicial decision has been already been made regarding termination. That is what the court is concerned with.
Right, I totally understand. That would justify that, man. With the deepest aspect.
How can the executive body can justify a judicial decision, right? That to recall the termination order, meaning thereby re-electing means that termination order stands recalled.
Right. Exactly. Yes.
And you are allowed to proceed.
Yes.
It can happen.
Yes.
But in between comes a judicial order.
Judicial order.
Otherwise, if that order is not there, yes, they are within their discretion to recall that order and to re-allot you to for the remaining work. In between comes an order which is without tender. The petitioner ought not to have been granted to execute the remaining part just by decision in a meeting. Right? They said urgency, whatever. But otherwise, if it is the work is minuscule, they ought to have gone for tender, re-tender for short. There is a provision for short tender.
Right.
They did not do so. I am not justifying his allotment.
Yes.
But I am questioning the way it has been done. That is what the court is concerned with. I am not either for applicant or I am not concerned with the applicant granted the work or the petitioner granted the work.
I understand.
Have you?
I totally understand.
Have you? Because we have to. We have to see whether our judicial order is respected or not respected.
Right.
That is what the court is concerned with.
This aspect, my lords,
this is going overreaching the decision of the court is not welcome.
I can only say at the cost of reiteration, my lords, because there was also a direction by the Honorable Single Judge to conduct an inquiry.
If he was allotted the work as far back as in the year 2022 or whatever, as soon as you came to know, you should have laid an independent challenge to it, that how can it be granted without any kind of...
I challenged it before the single judge. And the single judge refused to interfere with the order of cancellation. And in
the consequential...
Yes. That was also challenged, that they should not have been granted the...
It is there already.
Yes. That was also there, my lords. But with that part, the learned single judge held that there are a lot of anomalies in grant of work to the present petitioner. So he conducted an inquiry.
Fact-finding inquiry would have led to his termination.
Yes. That was
perhaps.
Yes.
Right. That is done. But could not have led to revival of the termination order.
Yes.
Right. Yes, it could have led to his termination. And I think punitive action is taken, perhaps. Right. But
pension has been stopped.
The vice versa, that your thing will be revived.
Yes. The only answer to that would be, my lord, it's fraud, my lord. It was vitiated by fraud. And the department took consequential actions, my lord.
Yes. That is why they have taken action.
The other action also, because I have to be restored.
That does not mean that revival of the work order.
I have to be restored to the earlier position, my lord.
You should have challenged it. You had challenged already.
Yes.
You had challenged in the earlier petition.
Yes.
Where you made the fate of that it is justified.
Justified. Termination was justified. The other...
Okay, tomorrow we'll pass the order. Because I have many matters in the list.
My lord is disposing of the IA or the entire...
Yes,
in that case, just one last submission, nothing else, my lord. Now, my lord, the stand of the petitioners is that they have already completed the work. Assuming that to be true, but the fact-finding inquiry says no, some work is left. Now there's a timeline. 31/3 is the last day. So I pray, my lords, I may be allowed to continue and finish the infrastructure work, my lord, and later it would
when it is staged.
Yes.
when it is stayed,
Yes.
right, how can it be?
In fact, my lord, in the first.
When this, I think these two order 19/1/2026, and the other one is
20/01/26. So, my lord, in the first writ petitions, there was an order which was challenged, which was 19/8/2025. By way of that order also, I was allowed to resume the work, which was part of the challenge in the first writ petition. But the Honorable Single Judge had not stayed that order, my lord, but rather had passed an interim order saying that no coercive action should be taken against the petitioner. What would the petitioner gain if he has already completed the
we'll
work?
look into the other one tomorrow.
Yes.
Because I filed here,
They are not-
I'll
they are
look
not
into the facts
prejudiced.
of the other case tomorrow.
No, they are not prejudiced if I'm continued to work. They are not prejudiced. It's their stand, my lord, they have completed the work.
No, we are concerned with these two. Those are
That
challenged.
can be taken at the final disposal, my lord. Because
No,
the
their
work is
response is not there.
final disposal, my
And
lord.
we have a constitution obligation. You have put it. That is why I looked into it. You have put it under the garb of 226(3). So we have a constitutional obligation to dispose of.
Right.
Right.
Correct.
Had it been simple vacating petition, I would have done so. But I have a constitutional obligation also. The Honorable Supreme Court has said, so I have to dispose it of.
I would also take into account the public interest aspect. At least 31(3).
Public interest, Mr. Nayak to urge.
Lordship,
So in that case, the timeline can be extended. It will be beneficial for both.
No, they will extend.
Timeline, yes.
This work was allotted to him in the month of August 2019. Completion period was 1 year. And till the date of completion, his performance was only 40%. Now he is urging public interest.
PWD has.
He will urge now public interest.
He's arguing against.
He will urge public
P.
interest.
Mohanto, applicant.
Tomorrow,
P.
Lordship,
Nayak, tomorrow.
Lordship is going to deliver the order, or Lordship will
Order on the only I.
Please.
Only on the I.
Lordship will allow me to make my little submission, brief submission, Lordship.
Yes.
Lordship, if Lordship
Okay,
come-
tomorrow we'll hear you.
Lordship.
Before passing. Tomorrow we'll have some spare time to hear you at
Very small.
length,
Lordship.
because others are waiting today and this court is rising at 3:15. That is why.
Here us also little bit.
No, I have heard you enough. You have justified. P. Mohanto, applicant. Mr. P. Nayak, Learned Additional Advocate General for the state.
For the government Lordship.
Respondents. And Mr. DP Bora, Learning Counsel for the opposite party, the state petitioner. Release the case tomorrow.
Deeply obliged, man. I'm very grateful, man.
2403. For admission, item number 16.
Affidavit in reply. You have taken 4 years, 5 years time.
No, Lordship, they have filed
Heard Mr.
AAS.
A. Ahmed, Learned Counsel for the petitioner. Ms. Borua, here for?
1, 2, 3, and 4.
Okay, central government.
Yes, sir.
And Ms. S. Borua, Learned Standing Central Government Council for the respondent number 1, 2, 3, and 4. Any other respondents? Okay, Ms. Yudas, Learned Additional Senior Government Advocate for the respondent number 5 and 6. Mr. Ahmed has sought for and is granted 2 weeks time.
Lordship, we are filing it today, Lordship.
Okay. I have submitted that the affidavit in reply to the affidavit in opposition of the respondent number 5 is going to be filed during the course of the day. Post of list the case on so and so. As sought for by the Learned Counsel for the parties, list the case on so and so with the affidavit in reply of the petitioner of the court. After vacation.
Maharaj, I'm so sorry. This tender matter, can it be on Thursday instead of tomorrow? Scrutiny of nomination, I had some prior problem.
Thursday?
Thursday. I've taken consent of Mr. Nayak.
Okay.
I'm very grateful.
Have you informed Mr. DP Bora?
I'll inform DP Bora.
2603. 1415. Item 17.
It is not allowed to withdraw the same.
Look, last day you said submitting, okay. Miss S. Shutia Learned Counsel for the petition has submitted, an instruction, the petitioner wants to withdraw the writ petition, Mr. N. Goswami, Land Standing Counsel, Excise Department. Is all the respondents? Or the state respondents is present. To stop. In view of the above submission made by Ms. Shukiel and the counsel for the petition, the writ petition is dismissed on withdrawal.
Bless.
Yes, some prayer was made, no, morning. Yes, you for a petition.
Yes, my lord, I'm for item number 19.
19.
Earlier in the morning,
who?
item number 18.
For a petitioner?
Yes, someone has appeared and they prayed, but the court asked for the matter to be discussed.
Mr. PWD. Where is Mr. Gugoi? Second to Diok. Mr. Gugoi, B. Gugoi. Can anybody call Mr. B. Gugoi, Standing Counsel PWD? Or be there. Let Mr. Gugoi come.
Item numbers 20 and 21.
Please, John.
Yes, Mr. Das.
So in this, pleadings and item 20 is complete. As far as 21 is concerned, the counter affidavit is still outstanding.
21.
The 2024 matter, Your Honor. 11 dates have already passed. And they're near identical matters. So they filed it in one, but not in the other.
21.
May I please, Lordship?
Respond number 1.
Yes, Your Honor. Respond number 1.
Lordship, it will cover the same only, Lordship. We will file it, Lordship. The affidavit we have already filed in WPC
Item number 20.
5063. That is item number 20.
That will cover the case.
Yes,
It will.
Okay. You are for the petitioners in both the cases.
These are
Both the cases.
yes, Your Honor. Then my rejoinder may also be read in the same manner.
Mr. Ridas. Then after view, then, Mr. Possible.
Very well, Your Honor.
What are the matters?
Your Honor, this is to do with provident fund dues that have not been deposited for the workers of a company called HPCL, Hindustan Paper Corporation Limited. It was run by the respondent number 1 through the Department of Heavy Industries. And from 2014 to 2019, the PF was deducted from my salary but never deposited. So
what is the stand taken in the first case?
the stand taken by the other side is that my stand, Your Honor. My stand is their stand is that the matter is pending before the NCLT, so it should go there. Whereas the NCLT is actually sent us back, and the law is also very clear that the PF dues are outside the NCLT purview of the NCLT IBC process. So here the issue will be who's a employer under the PF Act, because the respondent number 5 and 6, which is the EPF department, they have not even initiated recovery proceedings against the employer.
In the other case, respondent number 1 has filed affidavit.
Yes, they have filed. It's near identical, so it'll actually.
Third, Mr. Didas, learned counsel for the petitioners. Miss
P. Rabha.
P. Rabha, learned counsel.
On behalf of Ms. Egan.
On behalf of Ms. Ega and learned Central Government Council for the Respondent Union of India. Any state? Mr. P. K. Roy, learned senior counsel estate by Ms. A. Chakraborty for the respondent. Tell me the authority only. Regional Provident Fund Commissioner. For the respondent EPFO authorities. And who else?
And there'll be the liquidator.
I appear for it's number 4.
4.
AIDC.
Okay. Mr. D. Teka, Land Standing Council, AIDC Limited for the respondent. Standing Council AIDC. And who is for the liquidator? Miss P.
P. Soikyar.
P. Shoikyar, Learned Counsel for the respondent liquidator. Full stop. Ms. Rava has submitted that the counter affidavit filed on behalf of the Respondent Union of India in WPC number 5063 2024 will cover the case of the Respondent Union of India in the writ petition WPC number 5065 2024, and therefore there is no necessity to file a separate counter affidavit in WPC number 5065 2024. First of, in response, Mr. Das, learned counsel for the petitioner, submitted that the affidavit in reply filed by the petitioner in WPC number 5063 2024 would suffice in such a situation. First of, the other respondents have already filed their.
Well, they also filed an additional affidavit. After the reply they filed, I find that some more particulars are to be brought to you. There are subsequent developments as the additional reply says. There are subsequent petition filed before the NCLT. So, Lord, I have to bring those orders to the notice of this. An additional affidavit I filed.
Okay. Mr. Roy, learned senior counsel appearing for the EPFO has sought leave to file an additional affidavit in order to bring subsequent developments on record.
And I may be permitted to file any response if necessary.
Leave is allowed. The leave sought for Mr. Roy is allowed. The additional affidavit be filed within
10 days time.
within 10 days time, full stop. The petitioner may file its response within next
7
weeks.
2 weeks.
Within next week's 2 weeks thereafter, if so advised, full stop. List the cases.
Your Honor may consider 30th of April.
May.
7th May.
05.
Your Honor may just give me a minute. Very well, Your Honor.
Right.
Item 22.
My lord, in regard to this item, before my learned friend starts, my lord, can I be accommodated for some other date?
Okay.
Preferably after BU vacation.
Yes, we are also tight before BU.
I understand, my lord. And today, I think this court is rising early, so.
And next 2 days also perhaps.
My lord. But my lord, considering the urgency that is associated.
This is election time.
My.
The Chakraborty for the petitioner and Mr. S. Dottal as senior counsel for the respondent municipal corporation are present. First up, as an accommodation is sought by Mr. S. Dottal, list the case on.
Look, can it be on subject to convenience of my senior?
Let us be on 27 April.
My lord, what I was suggesting, it can be disposed of at the admissions. Can it be on a hearing date, my lord?
We'll put it on 27, thereafter require 28.
My lord.
Right.
27, I may not be. 28.
Is it not? Not 28. I don't readily fix
My lord.
unless I have a look at it. 29.
20.
Obliged.
Obliged.
Thank you.
Timing method. Items 18 and 19.
I see. Yes, Mr. Gogoi,
Well,
in 19, it is already 6 years.
Yes,
No affidavit. Oh. This does not show you in good light.
My lord, I'll find my affidavit in that person. It's the main contractor, I suppose, my lord.
They were.
I
You
will
filed
file that.
that so
That
that
is-
both the cases can be together,
Not
taken up together.
My lord.
Because you sought last time you sought on 25/9/2024.
My lord.
So 1.5 years.
Probably thereafter it was not.
You said draft affidavit has been prepared.
It will be there, madam, in the, probably in the file, madam. Some
Okay.
paragraphs.
Mr. S.J. Sharma,
Item number 18.
item number 18. Okay. Land counsel for the petition in 18 and Mr.
And Gogoi on behalf of.
And Gogoi, land counsel for the petitioner in 19 at present. Post of the writ petition, the WPC number 336 of 2019 in the writ petition. No counter on behalf of the state response has been filed till date. Post of Mr. B. Gogoi, standing of PWD, has sought for and is granted 3 weeks time as a last opportunity to file the counter affidavit on behalf of the respondent PWD authorities. Post of lays the cases on.
4th May. 4-5.
But you file, please.
I will file them. Okay.
Item number 23.
Okay.
Wait, please, Your Lordship. Please, Lordship, we have received the additional affidavit filed by the petitioner today at 12:15, Lordship. We would like to take instruction on this, Lordship. Kindly 3 weeks time may be granted, Lordship.
Take your instruction, otherwise pleading is complete perhaps, right?
Yes, yes, Lordship.
Okay, Miss
Priyanka Dagar.
P.
Priyanka Dagar.
And counsel for the petition has submitted that an additional affidavit has been filed on behalf of the petitioner. Post of Miss S. Kemprai,
Lordship.
standing counsel AAAC.
Lordship.
And Mr. P. Nayak, additional advocate for the state respondent for present, is present. Post of Miss S. Kemprai, standing counsel KAAC, has submitted that she needs 3 weeks time to obtain instructions on the additional affidavit filed by the petitioner. Post of praise the Lord, is the case on.
4th May. 4-5.
My lords, if I may request for any other date except for 4th of May, there's a personal hearing listed in Delhi.
6-5.
Please, very obliged.
Objection.
24. Item number 24.
Yes, Mr. Ahmed.
Lordship, 1 week's time to file a rejoinder, Lordship.
Rejoinder. Okay, Mr. N. Ahmed, learning counsel for petition.
Yes, one and
Petitioners
three.
sought for and is granted 1 week time to file. Take 2 weeks time to file an affidavit in reply to the affidavit of opposition filed by the respondent number 3. Ms. Yudas, learned additional senior government advocate for the
Respondent number 3.
respondent number 3 is present.
1 to entry.
1 to entry
Mine.
is present. Okay, release the case on students.
2704.
Diploma.
Item number 25.
Yes, Mr. Sururi.
Lordship, here is the instruction in terms of court's order 6th of February. Lordship, they appeared, it could not be opened.
Could not be open.
Yes, Lordship.
Lordship, I pray for adjournment.
So virus infected.
Lordship, I pray for an adjournment, Your Lordship.
What more?
Lordship, the senior was present, Your Lordship, but a few minutes ago, Your Lordship, the senior suddenly
Okay,
felt unwell.
next week. Monday.
Any day.
Heard, Mr.
You Agarwal.
You?
Agarwal.
Agarwal, learning counsel for the petitioner, and Mr. B. Chaudhary, learning standing counsel, agriculture department for the respondents. Full stop. Mr. Chaudhary has placed an office letter dated 17/3/2026, received by him from the respondent number 3, containing the minutes of the departmental meeting of the departmental bid committee held on 27/2/2026, in deference to the order dated 6/2/2026. The instructions were placed by Mr. Chaudhary is kept with the case record. You have a copy with you?
Yes, Professor.
Before that, on the prayer of Mr. Surendra, learned counsel of the petitioner, the case stands adjourned to next Monday.
3003.
That's the instruction case is kept in the record.
3003.
26.
We filed the affidavit today, madam. We have a respondent number.
Okay.
3, madam.
3.
Yes, madam.
Financial sanction.
Yes, madam.
Okay.
Yes.
This sixth finance commission will be expired on 31st March, Lordship. And my matter was step 5th finance commission.
Mm-hmm.
Copy is not before the honorable court. Today we have filed it.
We don't have the affidavit. They are going to file it.
Okay. They serve copy today morning, Lordship.
Yes, my lord. Friday we tried by. But
We entered in petition on money claim on the basis of submissions made.
My lord.
Right. Otherwise, all this should go to the civil court.
My lord.
That's because the prayer is made for disposal, we are entering it. Otherwise, law is settled. Mr. S.N. Odhyapak, counsel for the petitioner is present. Miss Udas.
Yes, madam.
Learned additional senior government advocate Assam for appearing for the respondent number 1, 3, 4, and 5.
Probably I'm not. 5 and 6.
1,
1, 3, 5, and 6.
5, and 6. Has submitted that an additional affidavit.
Affidavit.
Sorry, an affidavit in opposition on behalf of the respondent number
3.
3 in reference to the order dated 27/2/2026, is going to be filed during the course of the day. Those stuff. Odhyapak Miss R.M. Borua, learned counsel on behalf of Mr. H. Olia, learned standing counsel, Finance Department for the respondent number 2 and 4 are present. Huh? Okay. List the case on so and so with the affidavit in opposition of the respondent number 3 on record.
3003. 3003.
Obliged.
27.
Yes, Panchayat. No affidavit.
Well, I have received an instruction, my lord. And as per instruction, my lord, the petitioner, they are already running, my lord. After the report,
what is the case about?
They have selected, my lord.
Hmm?
They have selected already, my lord. After
what is the case?
Case, my lord, my lord, settlement, my lord. And at that time, my lord, one lost toss was there, my lord, because of the same amount.
And after that, my lord, and after the inquiry, he was found correct, my lord, and he was running, man.
Running?
Yes, my lord.
Any settlement order already?
Already settlement order, yes.
What is your case? Let us see.
Your Honor, we have challenged the impugn order.
Let us see. What is your case first? Tell me before impugn order.
Your Honor,
Fishery?
we were running the market. We were issued the
Huh?
settlement, which is in
Umuki Saturday weekly market.
Yes.
weekly market. Yes.
That is pursuant to any NIT.
Yes, Your Honor. NIT
NIT is at page
12.
12. What is the date of the NIT?
But 17/7/2025.
11/6.
11/5.
11/5 or 11/6.
In synopsis, it's written as 5.
In the body of the reputation 11/6. And it is for settlement year 17/2025 to 36/2026.
26, yes.
Right. Then you participated.
Yes, sir.
You participated. Then what happened?
I was given settlement. Settlement order is in page 22.
22.
Yes. On 27/6/2025.
22. 27/6.
Yes. I was given settlement.
Settlement at 3,85,000.
Yes, Your Lord.
Right.
Yes, Your Lord.
Then?
27/6/2025.
Hmm.
Then after running for 2 months, the impugn order page.
In enclosing here a copy of the complaint submitted by Deepjyoti Das. Deepjyoti Das is respondent 7. In connection with lottery conducted in the office of the so-and-so on so-and-so for settlement of a claim matter. Pursuance of government notification.
The impugn order is on page 27.
Yes, I am reading it. So by that order, it was kept in abeyance.
Yes.
Yes.
Settlement was kept in abeyance.
Then your
Then
Lordship,
thereafter, what happened?
We have approached this honorable court and the interim order was passed. After that, we were running the market.
Which is the interim order?
No, order dated 1/8/2025.
What is the impugn order? Once again, page. Okay, additional chief secretary.
Your Lordship, according to 105, subsection 4.
Thereafter, some report was submitted.
Yes.
Right.
Actually, before the amendment, my lord, the government was the appropriate authority. Thereafter, after the amendment, my lord, it was shifted to CEO, my lord. That is why government referred the matter to CEO, my lord. And after the completion of the report, my lord, they are allowed to run, my lord.
They are allowed
They are
to
running.
run.
Yes, they are running now, my lord.
But that report has been submitted.
Report one from BDO, one report has been submitted. I have submitted one instruction, my lord. Place, my lord. As per this also, my lord. After the final report, my lord, and the undersigned has no objection if running the said market by the city university does, he is a petitioner, my lord. So they are allowing, my lord.
This is allowing by the, on the strength of the interim order or
After the interim order, my lord, the report has been submitted.
report, that is,
Block level.
no, this instruction is silent on it.
That perhaps it's not reflecting here.
That is not there.
Or lordship may fix the matter on after 1st July, my lord. It will become automatically infructuous matters.
That is not the way. That is not the way.
Otherwise, they are running, my lord.
Okay, we'll issue everything notice returnable by 52 weeks.
No, man.
This is not the way.
Otherwise, department doesn't have any objection to say they're running and they are also running, man.
No, whether report has been submitted or
One
not,
report-
you can close it.
I can submit the report, but they
That
have to.
instruction you can place.
Yes, man. Report
Then
already
we can
submitted.
close it.
They have to
And
do
with
no
response
action.
number 6,
My lord.
7. Has he entered appearance?
That
No,
part I
no.
don't know, my lord.
No, Lord.
Notice served or not, I am not aware.
Duly represented? Board of President would not like to issue notice. Okay, he has not been, okay. We'll place the report.
My lord. I'll
Place
submit
the
that.
report or obtain instruction the report that after the impugn order,
My lord.
a report has been prepared, submitted before the government. Government has in turn sent it to the CEO and CEO has accepted the report
My lord.
and petition has been allowed to continue with the settlement.
My lord, I'll look
That
into
is the requirement.
I'll look into it.
Otherwise, it looks like on the strength of the interim order.
Yes, my lord. I'll look into it.
We cannot close that.
Yes.
Have you understood?
Yes, I understand.
Okay. When?
Next week, next Monday, my lord.
Get it Friday.
I'll try.
Mr.
TL Chaudhary.
Land Council of Petition is present. First of Mr. Dotto.
As per telephonic instruction, they instructed that report has been submitted, my lord. If thereafter final order not passed,
See the text and tenor
My
of the
lord.
previous order passed in December,
my lord,
which is not showing you in good light.
my lord.
Is it not?
Yes, my lord.
So at least you have the responsibility to place.
My lord.
Not. You are not showing. You are not shown in good light.
My lord. Well, I'll place, my lord, because as per instruction
Don't
report
take
already-
much time now.
My lord.
Mr. Doctor, Learned Standing Council Panchayat and Rural Development Department. Appearing for the respondent number 1 to 6.
1 to 6.
Has submitted that as per the direction given in the impugn order dated 17/7/2025, a detailed report as regards the manner in which the conduct of the lottery was held on 26/6/2025 had already been forwarded to the government by the Chief Executive Officer Sonitpur Jila Parishad, Sonitpur, post of, as due to subsequent amendments and delegation of power to decide in such kind of matter, or to delegation of power to the Chief Executive Officer of the Jila Parishad to decide on such matters. The final decision was directed to be taken by the jurisdictional Chief Executive Officer. A decision has thereafter been taken by the jurisdictional Chief Executive Officer, observing that the process undertaken there is no infirmity in the process undertaken to conduct the lottery. And thereafter, the petition has been allowed to continue with the settlement of the market. To continue the settlement of the market. First off, he has sought listing of the case. Mr. Doctor has sought listing of the case on Friday in order to place detailed instruction. But first off, list the case accordingly also. And so the interim order past arrest shall continue till the next.
Right. I'll place one.
Hello.
Hello, please.
Item number 28.
Enough, no? Yes,
May it please,
madam.
we have filed our affidavit in reply today.
Okay, Miss S.
Roy.
A. Roy. What is the matter, Mr.
Lordship,
Upadhyay?
Lordship,
NID?
Lordship, NIT.
NID.
NIT was issued by the executive engineer. Date has, after a work order has been issued, the chief engineer noticed that Lordship he has issued the notice tender manually instead of Lordship e-tendering Lordship.
So he cancelled it.
He is cancelling Lordship.
A. Roy Land Council for petition has sought for and has submitted that the affidavit in reply to the affidavit in opposition of the state response number
Or
3.
two.
2 has been filed today.
Yes.
Okay. Release the case on April 1. We just said affidavit in reply and record.
April, Lordship? First April.
First April.
Oh, Robert.
If possible, we'll
Lordship.
consider the case that day.
Lord.
29.
Yes. Affidavit filed.
No affidavit filed. That's
Very formal.
Mr. Ha.
We have received the instruction and are sent for waiting, my lord.
Okay. BK Google petitioner. J. Hendik Revenue and Disaster Management Department for the response number 1 and Miss Udas Leonard, additional senior government advocate for the response number 6 and 7. Heard. Miss Das has submitted that the affidavit, draft affidavit in opposition has been sent for waiting. And given 2 weeks' time, the affidavit in opposition can be filed. Full stop. MS Das has thus sought for listing of the case after 2 weeks. Full stop.
This is last
chance. Prayer is allowed. Release the case on so.
As the last chance to file the affidavit.
Declined. Declined. To observe.
27.
2704.
They have sent draft affidavit. Definitely they will do.
Yes, my lord.
Last year questions is this happening, Lordship. That is why.
Item 30.
Last year questions. Obliged.
Item.
May I please?
Yes, sir.
Affidavit in opposition, affidavit in reply both filed. These are complete, my lord.
What is the case about?
Non-payment of contractual bill.
Non-payment.
Okay.
Okay, we'll fix a date. After we have to decide how much.
Page 7, my lord.
Acceptance or denial?
We have not even countersigned. That is also a grievance.
Huh?
There is a requirement of countersigning the bills by the chief engineer. That has also been not done.
Okay. Mr. Shroman, Council for petition, Miss Ting Loom, Learned Council appearing on behalf of the respondent Water Resource Department authorities, have submitted that the exchange of reading is complete. First one. List the case on friends.
4th May. 4th May. Item number 35.
Page 13 is the liability statement, Lordship.
Affidavit in file, affidavit in opposition.
It's admitted, Lordship.
Yes, DC. They put the blame to you. He is holding the money. They are saying, we don't have any responsibility. Pars is with him. Heard Miss K.K. Chaudhary, learned counsel for the petitioner, and Miss Tinglung, learned counsel on behalf of Mr. R.M. Das, learned standing counsel, Water Resources Department, for the respondent number 1. Four, 5, 6, 7. Article J. Handy, standing as Revenue and Disaster Management Department for the respondent number 2. Mr. Handy, be on alert. Deputy Commissioner will put the blame on you. Because it is Revenue and Disaster Management, he will say, I have no fund, revenue. So both.
They have to send their proposal to us.
We don't know. You file your affidavit. Both. Mr. In the affidavit in opposition of the respondent Water Resources, in the affidavit in opposition filed by the respondent number 4, comma, it is stated that the payment to the petitioner could not be released as the competent authority to make the payment under the State Disaster Response Fund SDRF scheme is the concerned district commissioner, Nagaon, within bracket, the respondent number 3. Post. And the Water Resources Department acts only as the supervising authority of the projects under the SDRF scheme. Post. Para, in view of such stand taken by the respondent Water Resources Department authorities, comma, the respondent number 1 and the respondent number 3 are required to file their counter affidavits 1 and 3. Oh, 2 and 3. Post of Mr. Hendik, Mr. J. Hendik, learned standing counsel, Revenue and Disaster Management Department for the respondent number 2, and Ms. Yuda, learned additional senior government advocate Assam for the respondent number 3, are granted 3 weeks' time to obtain the necessary instruction to file the counter affidavits on behalf of the said respondents. List the case on soils.
4-5.
Once they fail, we'll dispose of.
4-5. Item 36.
Here my instruction is awaited, my lord. G. Ugoi, learned counsel for petition is present. Mr. S. Bora, learned standing counsel GMC for the respondents has sought for and is granted 3 weeks' time to obtain the necessary to complete his instructions and to file the counter affidavit on behalf of the respondents. For all the respondents. List the case on swings.
4-5. Court me. 37.
May your lordship.
Yes, Ms. Bora.
I have received instruction. I may be allowed to begin the record.
Okay. Miss
S.R. Major Buyaloj.
S.R. Major learned counsel for the petition is present. Miss M.D. Bora, learned standing counsel IWT has submitted that the necessary instructions to file the counter affidavit are received. So M.S. Bora has sought for 3 weeks' time to bring the stand of the respondents by way of Counter affidavit. Full stop. The prayer is allowed. Release the case on sweats.
2404.
20. Obliged.
Item 38.
This is a lordship.
Mr. M.A. Churvil, counsel for the petitioner is present. Yes, nobody is present. PWD not present.
Notices were issued, madam, in this case. And if I may just appraise lordship one aspect, the petitioner also approached my lord in respect of similar work done under Algapur Revenue Circle, my lord. And the coordinate branch has directed the authorities to consider his representation and to.
Oh, no. Representation shall I bring to your notice? This representation one,
No, madam.
how the Supreme Court has commented.
There
There is no representation on behalf of the respondent PWD authorities, though the respondent PWD has
57
a
also.
set of standing counsels. Post
57 over.
be that as it may, post stop, let the case come up for ends of justice, we list the case again on next to continue. Miss Burwa, you represent PWD. So I am recording their absence.
First April. Item number 39.
I have filed my affidavit, management dispose of the matter. But admitted amount is lordship, there is a difference. They are seeking 5 lakhs. 5 lakhs.
1 minute, your affidavit.
Yes.
That's
my
number 3.
Lordship. We have admitted 4 lakhs 42,784. They have said it 5 lakhs 35,000.
And what about payment?
Payment will release my lord as soon as we get the money. So my lord may dispose.
From where?
The finance department. Proposal has already been.
Yes, madam. Your thing is limited to 4,42,784.
Lordship, they have filed in this, they have stated that.
For the balance amount, you go to civil court.
Yes.
That is fair.
Lordship, you may allow to file our rejoinder affidavit.
What improvement will do? If they are not going to admit, nothing will happen. Think it over. We put it on
Next week, Lordship.
next Monday.
Lordship.
Miss Eras K. Khan, Land Conservator Petitioner, and Miss M.D. Bora, Land Standing Counsels. Cooperation Department are present. Full stop. The stand of the respondent Cooperation Department has been brought on record by way of an affidavit filed by respondent number 3, wherein liability to the extent of rupees 4,42,784 has been admitted against the claim made by the petitioner for an amount of rupees 5,35,000. Full stop. Ms. So-and-so, Land Conservator Petitioner has sought listing of the case on so-and-so. The prayer is allowed, list the case accordingly on so-and-so.
Obliged. Obliged.
Item 41. May it please your lordships. My lord, this is.
No affidavit.
No affidavit is filed.
R. Sharma, petitioner present. Yes, health and family welfare, they have taken. They have gone out. Okay, it is 3 o'clock. No standing counsel like to remain in the court. Is it not, Ms. Das? The case is called up at 3 o'clock, 3 p.m. First up. None for the respondent. None for the respondents is found present today on call. Post of no counter affidavit has been filed till date. let the case come for, in view of non-representing on behalf of the petitioner, court is constrained to order for listing of the case again on suits.
Next week. First April. Item 42.
You call non-allotment.
My lord, 42, my lord, the secretary of the Gau Panchayat was supposed to give instruction, my lord. On election duty is not holding right now, my lord. So I need some time, my lord.
Heard me. After that only. Is it not? Heard me, then he will take rest for 2-3 days. Right?
Well, in the month of April, lordship may fix after 9, my lord.
Possible. If he is on election duty.
Maybe after 9 he will be free, my lord.
Okay, 9. Okay. L. Dekha, Learned Counsel of Petitioner is present. Mr. S. Dr. Learned Standing Counsel Panchayat and Rural Development Department has sought listing of the case after 3 weeks in order to obtain the necessary instructions and to file the counter video. Procedural list the case on so and so. Miss Udas, you were there. Udas for 2. Huh?
2404.
I know.
Item number 43.
Oh, Mr. Gogoi. Pharmacy, that R. Sharma. I recorded.
My instruction is awaited, my lord. I have communicated, my lord.
I already recorded.
My lord.
Absence. Yes. I'll remove that.
Yes, sir.
R. Sharma.
41.
B. Gogoi Ligedibo. Standing Counsel, Health and Family Welfare Department has authorized granted 3 weeks time to file affidavit in opposition. Please the case on sales. Give somebody in your place.
43, please. Seat 4.
43. There is, yes, ma'am.
Your Lordship,
Item
Lordship, I'm
43.
appearing on behalf of Mr. P. Naik for PW Lordship. We've just received our instructions yesterday. We would like to file affidavit, Your
Okay.
Lordship.
There is no representation on behalf of the petitioner today on call. Post of Miss R.M. Borua, Learned Counsel appearing on behalf of Mr. P. Nayak, Learned Additional Advocate General, for the response number 1, 3, 4, and 5. Has submitted the necessary instructions have been received.
Received, Your Lordship.
And the counter affidavit will be filed within 3 weeks' time. The praise law leads the case on so and so. Standing Counsel, J. Hendick. Standing Counsel, Revenue and Disaster Management Department, response number 2.
85. 8 May. Item 44.
Yes.
Lordship, no reply has been filed. This is the matter against debarment.
So, yeah, how much time?
3 weeks time maybe.
After Bihu.
Yes, sir.
Third, Miss
Continue.
Sri Goswami Learned Counsel for the petition and Mr. P.J. Soikia Learned Senior Counsel, assisted by P. Bordole, Learned Counsel for the respondent NHIDCL authorities. Postal. What order you have got?
Lordship, stay of the debarment notice. Paragraph 8, Your Lordship, last order.
Mr. Soikia has submitted that the counter affidavit on behalf of the respondent NHIDCL authorities will be filed within 3 weeks' time. 3 weeks' time? Okay. The request is accepted. Raise the case on so and so. The interim order passed is still completed.
6-5.
Thank you, Lord.
Supplementary list. Item number 57.
Lordship, respondent number 1 is supposed to file the affidavit.
My lord, in this matter, we have received instructions and for vetting also, my lord. But because of some technical problem that was have to be modified, my lord.
17398.
So I'm praying some more time, my lord.
We can report can you?
Despite the previous order, you are still taking time.
My lord, only because of these elections, my lord, we are facing very problem, my lord. The last such may be given, my lord. If we will not file, my lord, lordship may pass appropriate order, my lord.
Because we are constrained to pass this order. Seeing the situation to 6 years,
My lord.
7 years.
Last chance may be given, my lord. Because of this.
Only what
problem-
time? This he is not acting responsibly. Is he not? That's for number
My
one.
lord, actually,
Permission.
we have already one set for waiting, my lord, but because we have to modify some paragraphs, my lord. Only because of that, my lord.
Cost of 5,000.
My lord, that may not be, my lord, because last chance.
Cost of 5,000.
Last-
Last number one is not acting responsibly.
Last
6
chance-
years, no affidavit, definitely 5,000.
Some concession, my lord.
No concession. Court has spent so much time to pass the previous order.
But,
And it was on
lordship may
6/3.
pass, my lord, if fail to file
6/3,
affidavit.
6/3 and 20 days. Today is almost after 2 weeks. So still he has not acted.
My lord, lordship may give condition, my lord.
5,000,
If we will not file after
5,000,
on failing of, my lord.
7 days, or otherwise cost of 5,000. In the alternate.
10 days, my lord. 10 days, my lord.
Mr. Miss
Das, Lordship.
PP Dr.
Das.
Petitioner. As Dr. Standing Counsel, Panchayat and Rural Development Department for the respondent of one. NB Caster. Learned Counsel, Agodu Silo. And Miss U. Bora. Learned Additional Senior Government Advocate Assam for the respondent number 3, 4, and 5. Also. By the previous order, in the order dated, this court has entirely observed and para it will hit him. Para today, Mr. Dr. Standing Counsel, Panchayat and Rural Development Department for appearing for respondent number 1 has submitted that for regions beyond control, the affidavit in opposition, the affidavit on behalf of the respondent number 1 could not be filed today. Post of citing declaration of election. The respondent number 1 has sought for further 10 days time to file the file down affidavit in deference to the order dated 6/3/2026. Post of. In view of the grounds cited, Commander Court is reluctantly allowing the prayer. Post of. Prayer for 10 days. 10 days given out.
6/4 ultimately. 6 April, 6/4.
The case. The case be listed on 6/4/2026. Post of it is observed that in the event the affidavit is not filed on or before 6/4/2026, the respondent number 1 is respondent number 1 shall deposit the cost of it is 5,000. And the repetition with shall cost deposit the cost of it 5,000 within 2 weeks thereafter. Full stop. And the repetition will be taken up for consideration on the next date of listing. on the basis of material something.
Hello, please.
58. I don't know what 58.
Well, and in this case, as per the office note dated 23/2026, the amended cost title, though I have filed on 18/3/2026, the section is yet to receive, my lord. Not yet corrected.
Not yet corrected?
No. Let the matter be taken up after being vacation.
Is there any office note?
My lord, office note there, my lord, 23/2026, 203/2026.
Okay. Mr. R. Islam, learned counsel for the petitioner. And Mr. S. Doctor. Now standing counsel Panchayat and Rural Development Department for the respondent number. And Ms. N.B. Castor. Learned counsel on behalf of Mr. R. Gates. Now standing counsel Assam State Election Commission and Ms. Udas. For the respondent number 3. S. Doctor 1 and 2. Udas 4. So peruse the office note dated 20/03/2026. Okay, again PNRD.
Yes.
Man.
Yes.
We have filed our affidavit.
Huh?
In this case, we have filed.
Now it has come that opposing stance.
Yes, yes, my lord. Deputy Commissioner and the Commissioner.
Opposite stance.
Yes.
Release the case on Swens.
2404. 24th April.
Much applause.
Item number 59.
It is a lordship, IA number 938 of 2026.
Why is it also? The order was
We have filed an application for.
Oh, I or implement hard.
Hosted.
What was there? Oh, Dhubri Municipal Corporation.
It has to be deleted and then it has to be impleted as the chairman, chairperson, municipal board, Dhubri as respondent number 8 and the executive officer, municipal board, Dhubri as respondent number 9.
Hard Miss S.
Roy.
Roy. Learned counsel for the applicants. Mr. S.
I'm for 1, 3, 4, and 6.
Dr. Learned. Standing counsel, Panchayat and Rural Development Department for the opposite party number 1, 3, 4, and 6. Miss Udas, Learned Additional Senior Government Advocate Assam for the opposite party number
2 and 7.
and 7. Miss 5, Miss R. Chaudhary, Learned Counsel for the opposite party number 5. So stop. The instant interlocutory application is preferred, seeking implement of the following two authorities. Page 5 of Chairman so and so. As party respondent number
8 and 9.
8 and 9. No pin code. How to send the notice by speed post?
I will mention in the envelope.
How can it be?
No,
One, you made it municipal corporation, there is no entity. Now there is no address. How can it go? How you're careless? I cannot allow you with this kind of carelessness. See your page 5. And what is the duty of the council? To give the address. If it goes, goes. Otherwise, it will move around for next 6 months. Not even PIN code.
Sorry,
Yes, is it possible to deliver?
At least pin code may not be required.
I'll mention, I'll correct it, Milord.
If Dhuri is a village, I can understand. Dhuri is not a village.
No.
And without PIN code, I think nothing is permissible nowadays.
I'll correct it, Milord.
If I'll press, don't make all this. Stop envy of non-furnishing of proper details, Ms. Roy has sought for withdrawal of the application in order to file a trace. The prayer is allowed. The instant application is dismissed on withdrawal with the liberty to file a trace. At least the PIN code, there is a notification already of the High Court. Don't file without PIN code, I think. Is it not, Ms. Chaudhary?
Sorry, Milord.
Item 60.
Oh. May I please, Your Lordship?
Mr. Bora.
Yes, Lordship. Okay.
Yes, affidavit.
Miss,
My lord,
the accident report is already filed, Lordship.
No, that will not do, Miss. It is by way of an affidavit.
my lord, the
If report is there, be there, and where is APDC?
first occasion, my lord, last order, your lordship will find this honorable court directed me to serve the inquiry means report
Bring it
by
on the affidavit.
to both the councils, my lord, epidicial as well as the petitioner. And I have served it on the same day, my lord.
Mr. P. Boral, Learned Counsel for the petition, and Ms. Udas, Learned Additional Senior Government Advocate, Assam for the respondent number. Which respondent? That's number 5 is present.
Yes.
So stop. You bring it on record.
Lordship.
Ms. Das has sought for 2 weeks' time to bring the electrical accident inquiry report on record by opening keep it. Post of the Learned Standing Council APDCL. He is found absent today on call. Post of in view of non-representation on behalf. No affidavit has been filed on behalf of the respondent. APDCL authority is till date. Post of in view of non-representation, let the case be. In view of such non-representation, let the case be listed on so and so application. The respondent APDCL authority shall ensure that its counter is filed on behalf on or before the next date of listing.
24th April, 2404.
Orders, sorry.
Orders.
If orders are urgent, we will list it tomorrow. All the orders, if urgent, just give the number, we'll list it tomorrow. Right? Because I have to rise at 3:15. Right? All the orders. Admission to 9? All orders tomorrow.